I may be pardoned to make a mention, Your Lordship. Fresh WPCRL, habeas corpus matter.
With the modification of order. Only the petitioner's name is wrongly typed out. What's up?
Item 13, my lord. There is a BL Tripathi and others. They are not coming. Let it be appointed someone, my lord. Somebody is there. So that it can be heard next week, my lord.
No, that will do, but
Today we'll take up matter 18.
matter
18.
Council is there.
Yes, come. Leave.
So item number 13. 13 में संबित महांती को ये कर दिया पेपर बुक दे दिया
अन्य नागरिक को पत्र
Weekly list item number 18.
Lord, in 18, JCL, there is a Prem Patnaik was there. He already died, my lord. And the CRLA, Mr. Daspeda is there to 100, my lord. Both are there. Should we engage in anyone for the JCRL?
No, he will do this. Mr. Daspeda will do that. Because he is prepared in this case, so Tunna Sahu.
Tunna Sahu is concerned, he was convicted under section 302. And there's rest, we are appearing criminal appeal. They are convicted under section 201, Your Lordship, for 4 years. But if Your Lordship permit, I will do it for both.
So,
the FIR is a space 42.
Order be passed. JCRL number 37. Order for the. How many persons face trial?
1%. No, 3% face trial.
What happened to the other one?
Other two, Jone Tunna Sahu was convicted under section 302, Your Lordship.
Okay. That is JCRL number
37. 37. आपकी कुन्ना साहू और राजकिशोर साहू दी जने जो रहिले सेमानक conviction हला 201.
They have preferred this
criminal appeal.
CRLA.
Second, yes, madam.
CRLA 37. Okay.
One Tunna Sahu is the husband of the deceased. Well, pay FIR stage as space 42.
Just Tunna Sahu, it appears that the appellant Tunna Sahu faced trial along with two accused persons Tunna Sahu and Rajkishore Sahu alias Raju in the court of law in Session Judge Fulwani in ST case number 80 of 2007 for offences punishable under section 302, 201, 202 of the Indian Penal Code. And who accused Tunna Sahu and Rajkishore Sahu were further charged. No, this is Tunna. Tunna Sahu is charged under section 302, 201 and 202. So far, and so far as who accused Punna Sahu and Rajkishore Sahu alias Raj. They were charged under section 201, 202 of the Indian Penal Code. And the appellant Punna Sahu was found guilty under all the offenses charged, and the two accused persons, Punna Sahu and Rajkishore Sahu alias Raju, are also charged, also convicted under section under the offenses charged and sentenced accordingly. It appears that Punna Sahu and Rajkishore Sahu alias Raju have preferred CRLA number 37 of 2009 and Mr. B.S. Dasparida, Learned Counsel, is ready to argue the matter. So, Mr. Prem Kumar Patnaik was engaged as the counsel for the appellant Punna Sahu. Ever since his date, we engaged Mr. B.S. Dasparida to argue the matter for the appellant Ajama Ikascuri. Mr. B.S. Dasparida submits that since he has prepared the case thoroughly, he can argue the matter for appellant Punna Sahu today, and there would be no problem on his part. Accordingly, the hearing was taken up. Hearing is taken up. Yes, now you start. What is the FIR?
FIR is page 42. Man.
Yes.
Mu Raghunath Sahu. Raghunath Sahu is PW 15 year lordship, father of the deceased lordship. So and so ଲେଖି ସବିନୟ ରିପୋର୍ଟ ହେଇକି ଯେ ମୋ ଝିଅ ସୁନିତା ସାହୁ, ସେଟା ସୁକତା ସାହୁ ହେଇଯାଏ, ସେଟା ସୁନିତା ସାହୁ, ବୟସ 30 ବର୍ଷ, ଆଜକୁ ପ୍ରାୟ 14 ବର୍ଷ ହେଲା।
Who is Sunita?
Deceased.
Okay.
14 ବର୍ଷ ହେଲା ତୁମୁଡିବନ୍ଧ ଗ୍ରାମର ଟୁନା ସାହୁ, ପିତା ଦୟାନନ୍ଦ ସାହୁଙ୍କ
Punna Sahu is the appellant.
First case.
ଜେଲ୍ କ୍ରିମିନାଲ ଆପିଲ ଅନୁଯାୟୀ ବାହା ହୋଇଛି। 14 ବର୍ଷ ହେଲା ତୁମୁଡିବନ୍ଧ ଗ୍ରାମର ଟୁନା ସାହୁଙ୍କୁ ପିତା ଦୟାନିଧି ସାହୁଙ୍କ ବୈଦିକ ନୀତି ଅନୁଯାୟୀ ବାହା ହୋଇଥିଲା। ବାହା ହେବାର କେତେ ବର୍ଷ ପର୍ଯ୍ୟନ୍ତ ଖୁସିରେ ଚଳୁଥିଲା ଏବଂ ତାଙ୍କ ଔରସରୁ ପୁଅ ପପୁ ବୟସ 12 ବର୍ଷ, ପୁଅ ମିମୁ ବୟସ 10 ବର୍ଷ ଏବଂ ଝିଅ ମାମା 8 ବର୍ଷ ହୋଇ ଜୀବିତରେ ଅଛନ୍ତି। ଇତିମଧ୍ୟରେ ସ୍ୱାମୀଙ୍କ ନିର୍ଯାତନା ଯୋଗୁଁ ମୋ ଝିଅ ସହି ନ ପାରି ତୁମୁଡିବନ୍ଧ ଥାନାରେ 2003 ମସିହାରେ ଗୋଟେ କେସ୍ ହୋଇଥିଲା। ଏହି କେସରେ ଟୁନା ସାହୁ କୋର୍ଟ ଚାଲାଣ ହୋଇଥିଲା। ଉକ୍ତ କେସ୍ ଚାଲିଥିବା ବେଳେ ଟୁନା ସାହୁ ପୁଣି ଆସି ମୋ ଝିଅକୁ ଆଣି ତୁମୁଡିବନ୍ଧ ଗ୍ରାମରେ ରହି ଆସୁଥିଲା। ପୁଣି 2005 ମସିହାରେ ମୋ ଝିଅକୁ ଟୁନା ସାହୁ ନିର୍ଯାତନା ଦେବାରୁ ମୋ ଝିଅ ତୁମୁଡିବନ୍ଧ ଥାନାରେ କେସ୍ ଚଳାଇଥିଲା। ଗତ ପ୍ରାୟ 2 ମାସ ତଳେ ବ୍ରହ୍ମପୁର କୋର୍ଟରେ ମୋ ଝିଅ ଏବଂ ଟୁନା ସାହୁ ଶାନ୍ତି ସମାଧାନ ହୋଇ ଦୁବଗଡ଼ ସଦର ଥାନା ଠାରେ ରହିଲେ। ଗତ 27/2/2007 ତାରିଖ ଦିନ ମୁଁ ଜଣେ ସମ୍ପର୍କ ଠାରୁ ଖବର ପାଇଲି ଯେ ମୋ ଝିଅ ସୁନିତା ସାହୁଙ୍କୁ ମାରି ତୁମୁଡିବନ୍ଧ ଜଙ୍ଗଲରେ ଗୋଟିଏ ଗାଡିରେ ନେଇ ଫୋପାଡ଼ି ଦେଇଛନ୍ତି। ଏହା ଶୁଣି ମୁଁ ଦୁବଗଡ଼ ଯାଇ ଝିଅ ନଥିବା ଜାଣି ଲୋକଙ୍କଠୁ ବୁଝାବୁଝି କରି ସୁନିତାର ମଢକୁ ଜିପରେ ଗାଁକୁ ନେବା ଜାଣି କୁର୍ତ୍ତମଗଡ଼ ଗଲି। ସେଠାରେ ଜାଣିବାକୁ ପାଇଲି ଯେ ଟୁନା ସାହୁ ଝିଅର ଶବକୁ ଆଣି କୁର୍ତ୍ତମଗଡ଼ ନିକଟରେ ଥିବା ଦୁବୁରିପଦ ଗ୍ରାମ ନିକଟ ଜଙ୍ଗଲରେ ଫୋପାଡ଼ି ଦେଇଛି ଏବଂ ତୁମୁଡ଼ିବନ୍ଧ ପୋଲିସ ଘଟଣାସ୍ଥଳକୁ ଆସିଥିଲେ। ଉକ୍ତ ଦିନ ଶବ ସଂସ୍କାର ଦୁବଗଡ଼ ଗ୍ରାମର ଅନ୍ୟାନ୍ୟ ଲୋକ ଥିଲେ। ଟୁନା ସାହୁ ଓ ମୋ ଝିଅ ସୁନିତା ସାହୁଙ୍କୁ ମାରି ଦେଇଥିବା ଦାବି ରଖି ଏହି ରିପୋର୍ଟ ଲେଖିକି ଦେଲି ଯେ ଘଟଣାର ତଦନ୍ତ କରାଯାଇ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ଗ୍ରହଣ କରାଯାଉ। ପ୍ରକାଶ ଥାଉ କି ମୁଁ ଜଣେ ବୃଦ୍ଧ ଲୋକ ବ୍ରହ୍ମପୁରରେ ରହୁଅଛି। ମୋ ଝିଅର ହତ୍ୟା ବିଷୟରେ ଭଲ ଭାବରେ ବୁଝି ଥାନାକୁ ଆସି ଏହି ରିପୋର୍ଟ ଦେଲି। ଏଣୁ ଏହି ରିପୋର୍ଟ ଦେବାରେ ବିଳମ୍ବ ହେଉଛି।
The allegation is that first he threw the dead body in Dumudi-Bandha jungle.
ଆଜ୍ଞା।
Then he again took
ନାଇଁ ସେଇଠି ପୋଡ଼ି ଦେଇଥିଲେ।
ଫୋପାଡ଼ି ଦେଇ ଯାଇଛନ୍ତି। So to come to the charge page, let us see.
Page 48.
47 is the charge of Tuna.
Tuna.
So that is 302. On so-and-so date, at so-and-so, you committed murder. Sunita Sahu is the deceased. Okay, 302 ro year charge. Then all the three, 201, 202. 22 to 2007, knowing or having reason to believe that offense of murder has been committed for certain evidence, okay, to disappear also. Then again, all right. So whether any eyewitness?
No eyewitness. Case is based on circumstantial evidence.
Now, there is eyewitness, but she told the hostile miller.
Who is that eyewitness?
That PW1, daughter of the accused and deceased.
Daughter of Tuna and deceased, right?
Deceased, yes.
But she did not support the prosecution.
Yes.
Okay, then what are the circumstances? Whether it has been summed up in the judgment anywhere?
Well,
These
Your
are the
Lordship, what
circumstances.
is the circumstances? The main circumstances is the postmortem report, Your Lordship. There is no other witness. Most of the witness turned hostile.
No, whether the circumstances have been jotted down anywhere in the judgment.
ଲେଖିଛନ୍ତି ଗୋଟେ ଜାଗାରେ para 14.
Para 14.
Para
Page
14. Page 33
33
of the judgment. The paper.
These are the circumstances. Please read it also so that.
Well, Roman 1. That the accused Tuna habitually tortured the deceased, and earlier 2 occasions he had deserted the deceased, and later, after compromising with the deceased, brought her back. That the accused Tuna, about a month before the death of the deceased, affecting compromise with her daughter from her parents' house, and shifted his residence from Tumudibanda to Dubagad and stayed later in the village in a rented house of PW3 along with the deceased, although he had stated before PW15 that he will stay at Fulbani. Thus, he wanted to keep a secret of his place of residence from his in-laws. That the deceased was made unconscious by pressing her nose and mouth by a pillow, and thereafter spread a message in the village that the deceased died of diarrhea, and deceased was not shown to anybody, including the own daughter, PW1. That the accused Tuna asked for help from the villagers of Dubagada for cremation of the deceased, and the villagers, suspecting foul play, advised the accused Tuna to report the matter to police and also send message to the parents of the deceased. That the accused Tuna and Raja went to Fulbani and brought the commander-chief of PW6 on hire, which was driven by PW5, and the jeep in the night on 22 to 2007, the unconscious body of the deceased was shifted to from the rented house of the accused Tuna to the jungle situated at near village Buduli Pada. that the accused Tuna had approached PW25, a villager of Kurta,
Kurtamagoda.
Uttamagada, to help him to disposing of the body of the deceased, saying that she died of diarrhea and the body of the deceased is in commander jeep. That the deceased was burned alive, causing her death at about midday time at 23/2/2007, and her body being burned is recovered from the jungle. Sir, এটা ଲେଖୁଛନ୍ତି 5 ଟା ଦେଖନ୍ତୁ. The accused Kunna and Raja went to Fulbani and brought commander jeep of PW6 on hire, which was driven by PW5. In the jeep, in the night of 22/2/2007, the unconscious body of the deceased was shifted from the rented house to the accused of Tuna to the jungle situated near village Budulipada. ଆପଣ PW5 ର evidence ଟାକୁ ଦେଖନ୍ତୁ.
No, on this point there would be two witnesses.
ଆଜ୍ଞା
5 ଆଉ 6.
5 ଆଉ 6 ଦି ଜଣଙ୍କର
କାରଣ 6 ଟୁ ଆପଣ ଗାଡି ଆଣିଲେ,
ଆଜ୍ଞା
ଗାଡି ଚଲଉଥିଲା 5
ପାଞ୍ଚ।
ନମ୍ବର ସାକ୍ଷୀ,
ଆଜ୍ଞା
ତାପରେ ଆପଣଙ୍କ ଘରୁ
ହଁ।
ସେ ଡେଡ ବଡି କୁ ଶିଫ୍ଟ ହେଇଛି ମାନେ
ଜଙ୍ଗଲ।
ରେଣ୍ଟେଡ ଘରକୁ, ଆପଣଙ୍କ ଘର ମାନେ ରେଣ୍ଟେଡ
rented ଘରୁ
ଜଙ୍ଗଲକୁ ଯାଇଛି.
ଆଜ୍ଞା।
So these are two vital witnesses.
witness.
Also PW25.
25 ଟା କଣ କହିଲେ?
Yet at the extra that Tuna had approached PW5, 25, a village of transfer to help him in disposing the body of
ହଁ ଏଇଟା ଗୋଟେ ବାକି ବଣ୍ଡ ଟାଲି ରହୁଛି ପୋଷ୍ଟମର୍ଟମ
ପୋଷ୍ଟମର୍ଟମ କରିଛନ୍ତି PW ଡକ୍ଟର ହଉଛି PW8
ଆସିବ, ପ୍ରଥମେ ଆଗେ ସେଠିକି ପଳେଇ ଆସିବ ଦେଖିବ. Yes.
On 24/2/2007, I was the medical officer attached to SD Hospital, Baligoda.
Evidence of PW8.
PW8.
Page
80. I conducted postmortem
Wait.
on 80 page.
Yes.
On the day of 12:30 noon, I conducted postmortem of the dead body of Sunita Sahu, wife of Tunna Sahu. A police requisition after dead body was identified by so and so. The body was affected by 100% burn with absence of left leg and exposure of leg tabia and fibula. There was gross destruction of abdominal cavity with absence of spleen and kidney. The rigor mortis is absent. The face is sallow and distorted, and the tongue was protruded. Limbs and flexed with fist clenched, and the body was slightly bent. Hair, overscalp, and other parts of the body were signed. The spleen and kidney is completely burned and absent. The liver, heart, and lung are congested. The stomach was empty. Both the chambers both the ventricular chambers of the heart were empty, and the antral chambers is full of blood with blackish color. The pleural cavity contains blood stain, serious effusion. The black particles of soot mixed with mucus presenting the internal nares, trachea, and air passage. Cause of death: hemorrhage shock due to asphyxia and 100% burn. Nature of injury are antemortem. Age of death within 24 hours prior to post-mortem examination. The cause of death is due to asphyxia resulting from 100% burn. Exhibit 5 is my report. Exhibit 5/1 is my signature. I had opined the injury is antemortem. Cross-examination. I have not mentioned in my report that the death was due to asphyxia resulting the shock. To quote, the congestion of internal organ that is noticed is possible by pressing the mouth and nose by pillow, leading to congestion and then setting into fire. In the instant case, as there is presence of soot particle with mucus in the line of internal nares and trachea and the air passage, the possibility of strangulation of any kind is ruled out.
No, ସେ obviously ଯେତେବେଳେ ଡେଥ୍ ହେଇଯିବ
ଆଜ୍ଞା।
ସେତେବେଳେ ତ ନିଶ୍ୱାସ ପ୍ରଶ୍ୱାସ ନଥିବ ତ ସୁଟ୍ ପାର୍ଟିକଲ୍ସ ଭିତରକୁ ଯିବାର ଚାନ୍ସ
ନା।
ନାହିଁ। ତେଣୁ ମାନେ ସୁଟ୍ ପାର୍ଟିକଲ ଯେତେବେଳେ ପୋଡା ହେଇଛି ତାକୁ ସେତେବେଳେ she was surviving. So that is the reason why the soot particles were found.
Found in the yes.
Okay. But except born injury, there is no other external injury noticed.
100% bond मिला।
हाँ नहीं 100%
पूरा
born
पूरा आसी।
नहीं ମୁଁ କହିଲା କୌଣସି ମାନେ ମୁଣ୍ଡକୁ ବାଡେଇଲା ପରେ
ନା
ପୋଡିବା
ମୁଣ୍ଡ ବାଡି ସେ କହୁଛି ସୁଦୁରି putting a pillow on her mouth, pressing mouth and nose.
no ସେଇଟା କାହିଁକି ହବନି strangulation ତ rule out କରିଦେଲା ସିଏ କହିବା କଥା ଯଦି ପ୍ରେସିଂ କରିକିନା ଆପଣ ଡେଥ୍ କରେଇଦେଲେ
ନା
ତାପରେ
ସେତେବେଳେ ଡେଥ୍ ହେଇନି, ଅନକନସିୟସ୍ ଥିଲା। ତାପରେ ଯେତେବେଳେ ତାକୁ ପୋଡିଲେ ତାପରେ ଯେତେବେଳେ ପୋଡିଲେ ସେତେବେଳେ ସେ କନସିୟସ୍ ଥିଲା।
ନାଇଁ ସେ there is no such evidence. Is there any evidence? So ଏଇଟା ହଉଛି ଆପଣ ନା there is evidence that how she died.
Yes.
କିନ୍ତୁ ଆପଣ ଯୋଉ ମେଥଡ ଟା କହୁଛନ୍ତି ଯେ ପିଲୋରେ ତାର ପ୍ରେସ୍ ହେଇଥିବ ସେ ମରିଯାଇଥିବ ତାପରେ ପୋଡିଥିବ ତାହେଲେ ପୋଡିଲେ ତାହେଲେ ସୁଟ୍ ପାର୍ଟିକଲ୍ସ କେମିତି ପଶିଲା ଏୟାର ପ୍ୟାସେଜରେ? So that shows that she was surviving
at the time
when there was burning.
Yes.
Okay. ତେଣୁ all right ଇଏ ଗୋଟେ ଆଇଟମ ଆସିଗଲା but what are the other that
PW15 with the father
ମାନେ 5 ଆগে ଦେଖି ଦିଅନ୍ତୁ, ସେ ଯୋଉ କହୁଛନ୍ତି ଯେ କମାଣ୍ଡର ଜିପ୍ ରେ ନେଇକି ଗଲୁ ବୋଲି।
ସେଟା ହଉଛି circumstance number ସେ ଯୋଉଟା କରିଥିଲେ
5 ଆଗ 6 ଟା ଦେଖନ୍ତୁ, the owner।
ଆଚ୍ଛା
owner ଟା 6
accused Puna and Raja went to Fulbani, brought commander jeep of PW6
yes
on hire. The hire for the here. All right, hire. Then which was driven by PW5, and in that jeep, in the night of 22 so and so, the unconscious body of the deceased was shifted from the rented house of accused Tuna to the jungle, right?
yes
So let us come to that
PW6
yes.
I am the page 76.
76
He is the owner of that jeep.
commander jeep.
Okay, please.
I am the owner of commander jeep bearing registration number so and so was and PW5 was the driver of the vehicle on 22/2/2007. Jagdish was the cleaner. I know Raja and Tuna. I don't know Tuna. On 22/2/2007, all the three accused came to Fulbani and contacted me to hire my vehicle for journey from Fulbani to Tumudibanda via Dubagad. I agreed to give the vehicle on hire. The driver took the vehicle. I don't know what happened thereafter. Again says accused Tuna not come with other two accused persons to contact me. The vehicle was agreed to hire at the rate of 4 per kilometer. The vehicle never seized by police. I do not know if my brother produced any document of the vehicle before police, but the police delivered the document in my custody under Jimanam. Again says, one day police took the vehicle to police station. Exhibit 2 is the Jimanama which I have executed. I have received all the items which are mentioned therein. Sunil is my brother. From him the documents were seized. The vehicle and the documents were detained in the police for a long period. I cannot give the date of detention of the date of release. Exhibit 2/1 is my signature on the Jimanama. It turned hostile. Prosecution allowed to push question on 154 of evidence. Exactly, Your Lordship. It is not a fact that I have stated before the IO gote 22/2/2007 Rikho by a above quoted person in his 161 statement made exhibit 1/4 is subjected to prove read over to the witness, but is denies to have made such statement before the police. It is not a fact that I deposed falsehood only to save the accused persons from criminal liability. Examination by defense, no one has requested me to help the accused suppressing the truth. I know them frequently, meet them while passing on the way. I came to know that from overloading the vehicle was seized.
Yes.
So
So,
PW,
no, this witness stated those that even though he has stated that he do not know this, he doesn't know that apple and tuna, but he knew the other two, your client, and he said
the vehicle higher basis
right on 22. That's one circumstance. So this evidence that the vehicle was taken on hire by at least two of the appellants.
No, 3. Para 2 Miller. I know the Raja and Puna.
Just a moment.
Yes.
He said, okay, all of them, 3 persons came in. Subsequent again says, so they can look like.
Again says,
Again says.
accused Tuna had not come with other two accused person to contact me.
ଏଠି ବି କହୁଛି I do not know Tuna ବୋଲି କିନ୍ତୁ ତାପରେ କହୁଛି ହଁ all the three
accused
and contacted me so and so, but again says that Tuna had not come. All right, so far as whether Tuna has come or not come, there is some kind of discrepancy, but about these two other appellants who are convicted only for that 20, they had come and took that commander jeep on hire. All right, so
PW5 is the driver.
Okay.
जो गाड़ी चले के जाए 74.
Yes.
Anil Kumar Mahanti of Fulbani is the owner of Commander Jeep bearing registration number so and so. I was engaged by him as the driver of the vehicle. Jagdish Malik was the cleaner of the vehicle. The vehicle
You are
used to
placing PW5.
5
Yes.
mile. The vehicle used to make a frequent trip to Dadaki Chakka carrying passenger. I know Raja and Puna, accused persons. I don't know the other accused. About 8 to 9 months back, Raja hired the vehicle from his house at Dubagada and took Raja and Puna and other family members, all numbering 5, got into the vehicle. As per the requisition, I drove the vehicle to Tumudibanda. They got down there and I drove back. We did not halt any place on the way. I do not know anything else. The family members did not take any goods or luggage with him.
He was also declared hostile.
Yes.
Monagala, it's not a fact that I know one dead body was loaded in the jeep, second page, and drove towards so support colony. I was never by any of the accused or relatives who want to depose falsehood or so on.
Going in the jeep on that day.
So, Mr. Tripathi,
Yes, Miller.
whatever he has stated, apart from the fact that he has been declared hostile,
Yes.
So there is nothing from this evidence of this witness that any dead body at least was taken,
Yes, shifted to the
because their role is causing disappearance of evidence. So unless it is proved that the dead body was carried from the rented house of Tuna Sahu to another place, let it be jungle or anywhere, and there it has been burnt. So if that evidence is not there, merely because dead body was found in the jungle in a burnt condition, that would not be a factor to, cannot be a ground to convict them under. So
201.
who has stated that? Because it's a case based on circumstantial
Circumstance.
evidence, you said. So from, at least we see from the evidence of PW5 and PW6, 6 practically nothing, because
Nothing.
he's a,
Yes.
say that, but unless some material at least comes that the dead body was shifted in that vehicle was seized.
Yes, my lord. Seized.
So anything was found from that
No.
vehicle,
No.
blood stain which must be
সেটা তো
tallying with
কম।
the deceased blood,
ଆୟ କହୁନି।
କିଛି ନାହିଁ। ଆଉ କଣ ରହିଲା ମାନେ ଇଏଟା?
PW25 ଯୋଉ କହିଛି ତ
Yeah, hostile.
ସେ 25 ତ କିଛି କହିନି।
କିଛି କହିନି
25
hostile।
କିଛି କହିନି।
କିଛି କହିନି।
25
କିଛି
କୋଉ ବିଷୟରେ?
25 ଟାକୁ 6 ର circumstances ରେ ଆଣିଲି।
ଗାଡିରୁ ବାହାର କରି ସବୁ ହେଲ୍ପ କରିବାକୁ ଜଳେଇବାକୁ।
ଓହୋ, ହଁ 25 ଟା ଦେଖିଦବା ଟିକେ। କେତେ ନମ୍ବର ପେଜ କହିଲେ?
119। ସେ କହିଲା I do not know anything about this.
ଟୋଟାଲ ମନା
ଟୋଟାଲ
କରିଦେଲି।
ମନା କରିଦେଲି।
ଟୋଟାଲ।
बाकी bond tell you, let us say in view of postmortem report it is proved. Then you come the circumstance number 4, जोटाको page 34 रे paper book रो माने running page 34 रे दिया है। ये विषय की कहउछन? प्यार नंबर रोमान 4
ରୋମାନ ଫୋନ ବିଷୟରେ ପ୍ରାୟ
please come to the judgment, Mr.
Yes, my lord.
Tripathi.
Oh, yes.
Come to, we have gone to 1 to 4 5 6 and 7.
Yes. 4.
We find that 5 and 6 there is nothing.
119. From 23 to 2007 to the at about 12 minutes of time, the accused Tuna informed me that his wife was expired due to cancer and asked me to assist him for cremation to dead body. And he told me that the dead body of the deceased is inside the commander vehicle. And later I got the information that dead body of Tuna is the half-burned condition was lying in the jungle near the transfer.
That I got information file, but Pachi Uchi about Swan, so the accused informed me. That means it is that confessional statement.
Yes.
Tuna informed me that his wife had expired due to diarrhea and asked me to assist for cremation of the dead body, and he told that dead body of the deceased was inside the commander vehicle. Later I got information. See how ta sange jai na pila. He खाली only information ଦେଇଛି ବୋଲି, so that would be ଏଇଟା କଣ ଗୋଟେ ଦାଟ ଟା ଛାଡି ଯାଇଛି କି ଏ ବିଷୟରେ କହିଥିଲା? ବର୍ତ୍ତମାନ ତ କହୁଛି ବୋଧେ ପୋଲିସ ପାଖରେ ଏ ବିଷୟରେ କହିଥିଲା ଯେ ଟୁନା ଆସିଲା, ଟୁନା ଆସିକିନି କହିଲା ଯେ ତା ସ୍ତ୍ରୀ ମରିଯାଇଛି। PW25 ର evidence,
Yes, my lord.
page 119, last 3 lines you see. On 23 to 2007 at about 12 midday time, the accused Tuna informed me that his wife had expired due to diarrhea. How he informed, that is not there. Whether he had come to him to meet and or over phone, nothing is there. But he said that informed me that wife has expired due to diarrhea and asked him to assist him for cremation of the dead body. And He told me that the dead body of the deceased is inside the commander vehicle. But he did not say that I went and verify that commander jeep and that the dead body of the wife of the appellant Tuna was there. This thing he has not stated, because he thereafter his sentence is, later I got information that the dead body was half burnt condition, was lying in the jungle near village Balipada.
This suggestion might have been denied. So the word
Cross examination to decline.
no, and we are apparently the word and is missing. The entire suggestion and that is missing for us.
ତାର ଏଇଟା ଟିକେ ଦେଖିଲେ ଏଇ ଯୋଉ ଏଇଟା କଣ ନାଁଟା କଣ?
ରାମେଶ୍ୱର ସାହୁ।
ଏଇ ଟିକେ ବାହାର କଲ ଏଇଟା କେସ୍ ଡାଏରୀ ରାମେଶ୍ୱର ସାହୁ। Accused. That a cast statement. Back her. Accused. Then accused. Then next. Hmm. Just a minute. रामेश्वर तो और किसी नाम है कि नहीं रामेश्वर अच्छा जरूर से केस डायरी प्रथम बार तो से आओ तुम्हारा No. It's actually going to answer. You should find out from Zoom. So, what about this circumstance number 4?
କୋର୍ଟ ଟା କେତେ ଜଣ କହୁଛନ୍ତି ଯେ ସେ ଆମକୁ ଡାକିଲା PW3.
PW3 4. PW3 the owner of the house, which was rented.
PW3 4 हो गया 3 4 ही हो जाएंगे.
3 4 villagers.
What they have stated, PW3.
3 type.
I know the accused person, page 70.
70.
70.
Hmm.
I know the accused person. I know the deceased. Accused Turna and his family were staying in our house. He and his wife were found in all happiness. His wife died about 1 year back. When accused Raja's wife came and informed me about the death of the deceased, I had advised her to report the matter to the police. When she asked to give firewood for cremation purpose, I advised him to not to dispose of the dead body. I also advised accused Turna to report the matter to the PS, but the dead body was
You are
disposed.
reading PW3.
PW3.
Hmm.
But the dead body was disposed of before arrival of police. I suspected became deceased was hell and nearby, and her death was unnatural. ये भी hostile है गला. कोई 150 ଆଉ ତାକୁ ଆସି କହିଲା ରାଜାର ସ୍ତ୍ରୀ. ରାଜାର ସ୍ତ୍ରୀ ଆସି ତାକୁ ମାନେ
Who is that Raja?
ରାଜକିଶୋର ସାହୁ.
Rajkishore Sahu.
जो 201
Appellant.
Has he been examined? This Raja's wife.
Raja's wife.
No.
How Raja is related to Tuna?
नहीं राजा साहू उसी जो अपेलेंट नंबर जो जेल क्रिमिनल अपील
Raja
नंबर
Sahu is the
राजू.
Is he related to
yes.
Tuna?
Yes.
How?
ତା ଭଉଣୀର ହଜବେଣ୍ଡ ହଉଛି ରାଜା
Vinay Raja.
Vin.
Tuna.
ଟୁନାର.
ରାଜାର ଭଉଣୀକୁ ଟୁନା ବାହା ହେଇଛି
ବାହା
ଏଇଆ ତ?
ନାଇଁ ଟୁନାର ଭଉଣୀକୁ ରାଜା ବାହା ହେଇଛି. ଝିଅ ପିଉସା କହୁଛି ନା. PW1 says that Raja is my piusa.
କୁନା ହଉଛି younger brother of ରାଜା.
This is the ଝିଅ. She has been examined.
Yes, PW1
PW1
turned hostile.
ତା ପୁଅକୁ ବି ଏକ୍ସାମିନ କରାହେଇଛି. ସେ ବି hostile.
ସେ ବି
Then she was a minor. She
Minor.
Yes.
as her brother. No.
ସନ୍ ହଉଛି PW24 ଆଉ PW1 ହଉଛି ଡଟର.
So, Mr. Tripathi, you said that 3 and 4 state about that circumstance number 5.
but we find that he has just placed that PW3. So there is nothing that because it is somebody came who he is the wife of Raja.
Yes.
He came and informed. It's not that the Tuna himself comes and told that. And you have not examined Raja's wife, right? And the other witness you said PW4, you see that he said that I had not seen the dead body when the Tuna
Yes.
this so I have no knowledge if the accused is to so and so. Not pulling on well coaching. Okay, so there is no such thing in the evidence of PW3 and 4 to prove this circumstance number 4.
Let us come to the
ରହୁଛି
PW10 Miller, page
କୋଉଟା?
85.
ସେଇ point ରେ
Yes. Dead body.
ସେଇ dead body ଦେଖିବା
85 page.
just yes.
I know the accused persons. I do not know the deceased. I do not know any quarrel between the accused Tuna and his wife of the deceased. The deceased died about 1 year back. The deceased and her husband, accused Tuna, was staying in a rented house in our village. After the death of the deceased in the house of the accused Tuna, the dead body was taken in one commander jeep and cremated somewhere. I and my other villagers advised the accused Tuna to report the death of the deceased to the police and also send message to her parents. The accused Tuna did not listen to us. The accused Raju Sahu and accused Kuna Sahu came to Fulbani in a motorcycle and took back the commander vehicle in our village. And in that commander vehicle, the dead body of the deceased were taken away from our village. The accused Tuna originally belongs to Tumudi Bandar. About 1 month prior to that of the deceased, the accused Tuna came to our village with his wife and his daughter and stayed in the rented house. Now, cross-examination is very important, Your Lordship. The house of the accused Tuna was visible from my house as it situated in our street and a distance between 200 meters. I was not examined by police. I had not stated before the police that I advised accused Tuna to report to the police and send the message to the parents of the deceased about latter's death, and the accused Tuna did not listen to me and shifted the dead body of the deceased from our village in a commander jeep and cremated the dead body somewhere. I had not stated before the police that the accused Raju and accused Kuna went to Fulbani in a motorcycle and brought one commander jeep to our village, and the dead body of the deceased was shifted in that vehicle. I had not seen the shifted of the dead body of the deceased in the vehicle from our village. It is not a fact that I had not personal knowledge and deposing falsehood.
So ଏଇ ଯୋଉ line ଟା କହିଲା I had not seen the shifting
Yes,
of the
yes,
dead
yes.
body. So ଆପଣଙ୍କର ସେ circumstance ହଉଛି ଯେ ଇଏ ଅନ୍ୟମାନଙ୍କର help ମାଗୁଥିଲା
Yes.
to dispose of the
This was a dead body.
dead body. So you said that 3, 4 and 10 are
Yes.
the witnesses on this particular circumstance. And he has placed this evidence of the 3 witnesses. So where is that material?
None of them seen that dead body. Right?
Hmm.
And what he has stated in the examination sheet, in the cross-examination, he stated that he was not examined by the police,
Police, yes, ma'am.
and he has not stated so before the police. What he deposed in his
In a
examination.
examination sheet.
And if these 3 to 4 circumstance goes, That is 4, 5, 6, 7. These 4 circumstance goes, then rest of the thing, even if it is deceased was made unconscious by pressing her nose and mouth by a pillow and thereafter spread a message in so and so deceased died of diarrhea, and the deceased was not shown to anybody including her own daughter. So a point रे किए कहउछन ए जो प्रथम आगे पिलो आ ये कथाटा किए कहउछ एटा
ଖାଲି ଡକ୍ଟର
डॉक्टर गोड
ଡକ୍ଟର କିନ୍ତୁ ତାଙ୍କ ମେଡିକାଲରେ ଯୋଉ ଦେଇଛନ୍ତି ପୋଷ୍ଟମର୍ଟମ ରିପୋର୍ଟ ସେଗୁଡା କିଛି ଲେଖିନାହାନ୍ତି ଏଠି କୋର୍ଟରେ ପ୍ରଥମ ଥର ପାଇଁ ଏଇଟା କହୁଛନ୍ତି।
हाइपोथेटिकली से पचारिछंती प्रश्नटे जे एमती हेई परिबो कि से कहला हां जे सेटाও केमती conclusively से करदुन that is a circumstance as if somebody has seen that the deceased the appellant pressed the face of the or the nose of the deceased
yes ma'am
with that pillow and nothing is stated. याकु जस्ट पचारले जे एमती हेई परिबो डॉक्टर पीएम डॉक्टर कहला डेथ एमती हेई परिबो
ନା ଆଉ କେହି କହିନାହାନ୍ତି ସେ ବିଷୟ
Almost all the witnesses, including the daughter of the deceased,
yes
have stated that both of them, prior to that incident, both of them were
living happily.
living happily.
now the previous conduct of the accused Miller, he was 2 times was jailed behind the bar for torturing this deceased.
Who has stated that?
PW15 ତା
15
ବାପା କହିଛନ୍ତି।
The year of the
ସେ post occurrence witness ଆସିକି dead
Just
body
let us see that PW.
he is the informant.
He's the informant.
PW15
Oh.
94 page.
Father of deceased, no?
Yes ma'am.
Yes.
I know the accused Tuna standing on the dock. I do not know other 2 accused. The deceased is my younger daughter. The
Right.
accused Tuna is the husband of deceased Sunita. After the marriage, deceased stayed in the house of the accused Tuna situated as village Tumudibanda. At about 18 to 20 days prior to death of the deceased, about a year and 4 months back, the accused Tuna had intimated us that since some warrant is moving against him for execution, he with his family will stay at Fulbani. But in fact, the accused Tuna stayed with the deceased at village Dubagada. Before shifting Dubagada, there was some quarrel between the deceased and the accused Tuna, and that time the accused Tuna has assaulted the deceased and later went to the police station with bleeding injury, and the case was registered. The accused Tuna remained in jail in connection with the assault to the deceased, and later the accused Tuna was released on bail. After release from jail, the accused Tuna again assaulted my daughter, and in connection with that assault, a case was Baliguda police station was registered. My daughter Sunita had also filed a case claiming maintenance against her husband that accused Tuna at Barampur court. About 20 days prior to death of the deceased, the accused Tuna brought the deceased from Barampur after entering into a compromise with her and stated staying at Dubagada. About 25 days before, after the accused Tuna took the deceased to Barampur, I heard from one Taraka of village Muddam
Mundamari.
Mari that the daughter was killed. Getting this information, I contacted the elder brother of the accused Tuna son, who was staying in Tumudibanda for confirmation of message. Little later, he informed us over phone about the death of the deceased. Then we went to Tumudibanda PS, and there we heard the dead body of the deceased was already taken to Baliguda Hospital for postmortem. At Baliguda Hospital, I got my report scribed. The scribe read over the report to me, and finding the correctly written as per my instruction, I signed the report. I submitted to the police. I identified the dead body of the deceased at hospital. Exhibit 10 is already marked as report, and Exhibit 10 is my signature. 10/2 is my signature. The report was scribed at Baliguda and presented at the FIR at Sadara PS. I brought the Sadara PS, some police officer of Baliguda. I did not know the situation of Sadara police station. I received the information about the murder of the deceased on 22nd day of the month few days after Saraswati
Sivaratri.
Sivaratri. I was not examined by police after the affair. I had not written in. I had not written in my report that I had not stated before the police that the accused had intimated me that they will stay as Fulwani due to pending of execution of warrant against him. I had not also not mentioned in my report that after getting information from uh, Tarak Vichitra, I had also not mentioned in my report of telephoning to the son of the brother of the accused Tuna. I had also not mentioned in my report about the identifying of dead body of the deceased daughter. The accused Tuna stayed in my house 2 days and in the house of my other daughter about 10 days during compromise talk. It is not a fact that I have submitted a false report.
You come to the accused statement, page number 54.
तो ସେଥିରେ କହୁଛି
Come. Last question number 31.
ମିଛ କେସ୍ କରିଛନ୍ତି ଦୁବଗଡ଼ ଗାଁ ଲୋକମାନେ କହିବାରୁ ଆମ ବନ୍ଧୁବାନ୍ଧବଙ୍କୁ ଡାକିକି ମୋର ସ୍ତ୍ରୀର ଶବକୁ ଦୁବଗଡ଼ରେ ପୋଡ଼ିଥିଲୁ। ମୋ ସ୍ତ୍ରୀ ମୃତ୍ୟୁ ଝାଡ଼ା ବାନ୍ତିରୁ ହୋଇଛି।
No, so two things. There was an admission of that dead body was burnt. Number two, your statement was that it was on account of diarrhea. That she died, right? So, if this statement is also accepted, let us say that he partly admits that to have burnt the dead body. That means the dead body was set on fire by him in presence of the co-villagers. So, for 201, causing disappearance of evidence, the one thing is to be proved that he is aware that an offense has been committed. So unless you bring the case into that it's a case where either that unnatural death took place or it was a murder case, so he says about that it's a natural death, diarrhea. But you are stating that it's a homicidal death, let us say. So where is that material that it was a case of homicidal death? The material has come that they were staying together. Okay, in a
Death is
rented-
occur in his house.
No, where from you say that? How you said that? He said that yes, death has taken place, but he has given that it's a case of
diarrhea.
diarrhea. You said that it's a case of murder. So there is no eyewitness.
No.
The medical evidence at least does not indicate that it's a homicidal death. It's a case of burn. So it may be on account of accidental. It may be there is no such thing that any injury has been caused.
Other villagers advise him to report this matter before police. That is there.
But ହେଲା ସିଏ ମୁଁ କହିବା କଥା ସେଇଟାକୁ ବି let us say ସ୍ତ୍ରୀର ଡେଥ୍ ହେଇଛି ସିଏ ଯାହା କହୁଛି ଝାଡା ବାନ୍ତିରେ ତାର ଡେଥ୍ ହେଲା ତାକୁ ଗାଁ ଲୋକମାନେ କହିଲେ ତତେ ଥାନାରେ ରିପୋର୍ଟ ଦେ ସେ କହିଲା ଯଦି ଇଏ ଭାବୁଥିବ ଯେ ମୋ ସ୍ତ୍ରୀ ତ ଝାଡା ବାନ୍ତିରେ ମଲା ମୁଁ କାହିଁ ଥାନାରେ କଣ ପାଇଁ ରିପୋର୍ଟ ଦେବି ଏଇଆ ଯଦି ଭାବିକିନି ଜଣେ ଝିଅ ଶବ ସଂସ୍କାର କଲା ତାହେଲେ କଣ 201 ଅଫେନ୍ସ ଆସିବ
and that the previous conduct
dispose of କଣ ଏଇଟା ନ୍ୟାଚୁରାଲ ଜିନିଷ ଆପଣଙ୍କର ଯୋଉ ଯିଏ ଝାଡା ବାନ୍ତିରେ ଯାହା ଘରେ ଇଏ ମରିବେ is he required to intimate is it an unnatural death then it is to be brought into the notice but it's a natural death.
In this accused statement, no question was put to the accused that when the deceased was unconscious, she was burned.
ନାଇଁ ସେମିତି କିଛି ନାହିଁ।
ସେମିତି ନାହିଁ।
ନା ସେମିତି କିଛି ନାହିଁ।
So question of murder କୋଉଠୁ ଆସିଲା?
ଆପଣଙ୍କର
ପୋଡ଼ିଲା ବେଳେ ସେ ବଞ୍ଚିଥିଲା। ତ ବଞ୍ଚିଥିବା ଅବସ୍ଥାରେ ଅନକନସିୟସ୍ ଅବସ୍ଥାରେ ପୋଡ଼ିଦେଲେ।
ପୋଡ଼ିଲେ
ସେଟା ଖାଇ
ଶୁଣନ୍ତୁ ଆପଣଙ୍କର 201 ୟୁ କମ୍ 201 ର ଯୋଉ ଫାର୍ଷ୍ଟ ରିକ୍ୱାରମେଣ୍ଟ whoever knowing or having reason to believe, these are very important things.
Yes.
Knowing or having reason to believe that an offense has been committed, okay, by him or by somebody else, possess any evidence of commission of that offense to disappear with the intention of screening the offender from legal punishment, or with that intention gives any information respecting the offense which he knew or believes to be false. It ଆସିବନି ଏଠି, but that he caused the disappearance, ଏଇ ଯୋଉଟା ରହିବ, first requirement is to be that he knew or having reason to believe that an offense has been committed. ତେଣୁ ଏଠି ଆପଣଙ୍କର କୌଣସି ଡାଇରେକ୍ଟ ଏଭିଡେନ୍ସ ତ ନାହିଁ, circumstantial evidence ଅନ୍ୟମାନଙ୍କ ପାଖରେ କହିଲା ଯେ ମୋ ସ୍ତ୍ରୀ ଝାଡା ବାନ୍ତିରେ ମଲା, ହେଲା, ଡେଡ୍ ବଡି ଏବଂ ତାପରେ ପୋଡା ହେଇଗଲା, ପୋଡା ଅବସ୍ଥାରୁ ଇଏ ହେଲା, ପୋଡା ପୋଷ୍ଟମର୍ଟମ ରିପୋର୍ଟରୁ ଜଣା ପଡୁଛି ଯେ ମେ ବି ଦ୍ୟାଟ୍ in the dead body it was that the body was burnt at that time she was alive. ସେଇଟା ଆସୁଛି ମାନେ ତେଣୁ let us say you whatever ସେ ଝାଡା ବାନ୍ତିରେ ସିଏ ଭାବିଲା ମରିଗଲା, but actually he was not dead. Then the dead body was consigned to flame in presence of the villagers, and thereafter these things had happened. So what material is there that he knew that the offense has been committed? He does not dispute that the dead body was burnt.
Yes.
ସେ କହୁଛି ଯେ ମୋର ସ୍ତ୍ରୀକୁ ଜୁନାଗଡ଼ରେ ଆମେ ପୋଡ଼ିଲୁ କାରଣ ଝାଡା ବାନ୍ତିରେ ତାର ମୃତ୍ୟୁ ହେଇଛି ବୋଲି କହୁଛି। ସମସ୍ତଙ୍କ ପାଖରେ ମଧ୍ୟ ସେ କହୁଛି ଯେ ଝାଡା ବାନ୍ତିରେ ହେଲା, କେହି କହୁନାହାନ୍ତି ଯେ ଆମେ ବଡିକୁ ଦେଖିଲୁ, ବଡିରେ କୌଣସି ଆଘାତ ଚିହ୍ନ ଥିଲା ବା ଏମିତି, ଇଭେନ୍
ବଡି କେହି ଦେଖିନାହାନ୍ତି,
ବଡି କେହି ଦେଖିନାହାନ୍ତି। ଡାକ୍ତରଙ୍କର ଯୋଉ ଏଭିଡେନ୍ସ ଆସୁଛି ତା ଦେହରୁ ମଧ୍ୟ କିଛି ଜଣା ପଡୁନି କୌଣସି ଏକ୍ସଟର୍ନାଲ ଇଞ୍ଜୁରୀ ଥିଲା ବା କଣ ଥିଲା। ଆପଣ ଗୋଟେ ଡାକ୍ତରକୁ ଗୋଟେ କ୍ୱେଶ୍ଚିନ୍ ପଚାରିଦେଲେ ଯେ ଇଞ୍ଜୁରୀକୁ ଆଭଏଡ୍ କରିବା ପାଇଁ, ଯେ ଇଞ୍ଜୁରୀ ତ ନାହିଁ, ତେଣୁ ପବ୍ଲିକ ପ୍ରସିକ୍ୟୁଟର ପଚାରିଦେଲା ଯଦି ତା ତକିଆ ତା ନାକରେ ଦିଆ ହେଇଯାଇଥିବ ତାହେଲେ ଡେଥ୍ ହେଇଯାଇଥିବ, ସେ ଯାହା ବି ହଉ, ତେଣୁ ସେମିତି ହେଇଥିଲେ ଡେଥ୍ ହେଇଯାଇଥିବ। ତାପରେ ତ ସେଇଟା ଯଦି ଡେଥ୍ ହେଇଗଲା ପରେ ପୋଡିଥିବ ତ ପ୍ରଶ୍ନ ଉଠୁନି ଇଏ ଯିବାର ନା, ସୁଟ୍ ପାର୍ଟିକଲ୍ସ କେମିତି ଯିବ?
This DW1, this is daughter. She has stated the reason why they shifted to that village. She has stated.
Yes, ma'am.
Paragraph. I know that my mother is dead. My father is in the court, so and so. So they are in the court. At the time of my mother died, we were staying in Subangada. I was with my parents at so and so. My brothers were staying in so and so. My parents left the village, being excommunicated by other co-villagers. They alleged that my mother had taken food in the house of a scheduled caste. That was the reason for which they shifted to another village.
Yes.
Myself and my so and so went to another village to attend the feast. Brother's house so and so and so. Prior to her death, my mother was living happily with me. They were never seen in court. Excepting the deceased father, no witness have stated that they were not feeling well. They were And in the accused statement also being suggested, he has denied regarding initiation of criminal proceeding against him for beating his wife.
Other is PW 15 million.
15 million. Informant.
The criminal case number कौन किसी नहीं reference.
ये जो डॉक्टर डॉक्टर को ही पारे सिर्फ धर মানে আশ্চর্য डॉक्टर is PW 15 ना
PW 8.
PW 8 ठीक 24
If the court was biased to convict the accused.
there was presence of soot particles mixed into answer
सर पता नहीं ही पर ना है इधर. We have come across many news items where thinking that the person has died, he was taken to cremation ground, so it is a uti
unless it is thoroughly checked out there may be something because motionless body को भाभी नहीं आती
Dead.
doctor can say
Declare.
if they declare that after examining the body he can say that yes whether
Yeah, doctor ବେଳେ ବେଳେ ବି declare କରୁଛନ୍ତି dead ସେ ବି ଉଠି ଯାଇଛି.
clinically dead ହେଲେ ସେ examine କରନ୍ତି obviously
Yeah.
nerve
Yes.
stethoscope ये सब जिनिଷ ଇ କରିକି ଜାଣି ପାରନ୍ତି then it is declared that clinically dead otherwise ସେମିତି just motionless ରେ ପଡ଼ିଲେ ତାକୁ but here the peculiarity is that the court put a question that since the why the strangulation is ruled out.
Yes.
He said that if it would have been a case of strangulation, then soot particles would not have entered to the air.
Entered in the-
That's
yes,
100% correct.
Yes.
Because after death, there is no question of
Question of-
taking breath, so that will not go there. But again, if you say that it was a case of smoothering, that means the pillow was placed on the mouth. So death has occurred. Thereafter, if you burnt the dead body, where is the question of soot particle again? So either way, it is not possible unless person is
Yes.
taking his breath, it's not possible to shoot at it. How it will enter into the air passes? And this suggestion has been accepted that as if death has occurred in that way. And the most of the witnesses, including their the daughter, stated that they were living happily.
Now they are pulling well.
Okay,
Yes.
they were blessed with 2 children. The
Three.
reason,
Three.
huh?
Three children.
3 children. The reason for coming to this particular village where the death took place is that the villagers excommunicated them. So that is the reason why they left one village, came to stay here. And ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ଯେ ତାକୁ କୁହାଗଲା କେତେକ ଜଣେ କହିଲେ ଯେ ତମେ ଯାଇ ଥାନାରେ ରିପୋର୍ଟ କର।
Yes.
କିଏ ସେ ସାକ୍ଷୀ ସବୁ?
PW.
Who has stated that they advise the appellant to report?
PW 10.
Just a minute. PW 10 then?
PW 10 କିନ୍ତୁ କ୍ରସ୍ ରେ କହିଲା ଯେ ମୁଁ କିଛି କହିନି ପୋଲିସ
No,
Told
no.
I was never examined by the police. Neither I was examined by police, nor I stated so before the.
Okay.
3 or 4
3.
PW 3.
Yes.
Just a minute. Let us see that 3 and 10 କଣ କହିଛନ୍ତି।
3 କୁ ରାଜାର ୱାଇଫ ଆସି କହିଲା।
ନାଇଁ PW 3.
Raja is one of the co-accused.
Co-accused 201 is conviction.
I know the accused. I know the deceased accused Tuna with his family staying at our house. He and his wife were found in all happiness. Okay. His wife died 1 year back. When the accused Raja's wife came and informed the death of the deceased, I had advised her. ତାମାନେ ସେ ତାକୁ କହିଲା କାକୁ
ରାଜାର ୱାଇଫ
ରାଜାର
wife କୁ କହିଲା ଯେ to report the matter to the police station. When she asked to give firewood for the cremation purpose, I advised him not to dispose of the dead body. I also advised accused Tuna to report the matter at the police station. But the dead body was disposed of before arrival of the police. I suspected so and so. It's a non-natural death. My house is at a distance of 200 meters away from Tuna's house. It's not a fact that I have not stated before the so and so that accused Raja's wife came to me, informed about the death of the deceased. I have not seen the dead body. It's not a fact that no such occurrence. I usually stay outside my house during daytime and I'm sure it's not a fact. Not seen because I'm happy the death was not. The IO is PW?
There are 3 IO.
Hmm.
One is retired PW 7, 9 and 19. PW 9 filed the charge sheet.
Mr. Das, you are there in this case?
It was trusted to Mr. Patnaik. But demise of Patnaik, it has come to me.
How it came? मतलब माने केमती माने आपन को कोड देले ना सीए दे देइतले No, the problem is that it's a jail criminal appeal. So
After that, Clapama was filed.
hmm,
My name was also there, but brief was with Mr. Patnaik. After his demise, that brief was given to me.
then you argue the matter. There is no problem. We have engaged him because nobody was there.
Not there.
Just you assist. His name, let him be there. So
During the entire prosecution, but the finding is based on suspicion. There is no concrete evidence which can be considered for recording a conviction. VW 10 and 15, these two witnesses have been relied upon by the trial court from the 10 is a person who has not been, for the first time he deposed in the court. So this evidence cannot be relied upon because he has never disclosed before anybody.
no, your case is that in the accused statement also there is an admission that is at page. You have got the paper with you. Please come to that paper. We are showing that accused statement to him also. The accused statement. Last question, right? Last question is dita jinso kouchi. Gote jinso houchi je ଆମ ବନ୍ଧୁବାନ୍ଧବଙ୍କୁ ଡାକି ମୋର ସ୍ତ୍ରୀର ଶବ ଦୁବଗଡରେ ପୋଡିଦେଲୁ।
ଦୁବଗଡ ଗାଁ ଲୋକମାନେ କହିବାରୁ
ଦୁବଗଡ ଲୋକମାନେ କହିବାରୁ
ବନ୍ଧୁବାନ୍ଧବଙ୍କୁ ଡାକି
ଦ୍ୱିତୀୟ କଥା ହଉଛି ମୋ ସ୍ତ୍ରୀର ମୃତ୍ୟୁ ଝାଡା ବାନ୍ତିରୁ ହୋଇଛି। So the fact that he burnt the dead body, that is an admitted fact. So the question is again,
in presence of his
in presence of.
relatives.
So again, question is that merely because he burnt the dead body, 201 would not be attracted, because he must be aware or knowledge that an offense has been committed, and in order to screen the or causing disappearance of the evidence, if he does that, then note it. The evidence is lacking. What he says, that it is either a homicidal death case or an
Exactly.
yes. So
That is no finding. That the deceased died out of homicidal death. That is not it. And on the contrary, let me see.
No, apart from that, no question was put to him during accused statement that while his wife was alive, she was burnt. There was no such suggestion.
That was not.
And other witnesses also have not stated. Only it is being revealed from the medical report.
Medical only suggestion.
suggestion.
So suggestion to the medical officer, not the evidence. And you are also kindly gone to PDL 15. Very
Other.
FIR itself creates suspicion. Why I am so sure? Last paragraph, last part of the chief. I'm reading out. At Baliguda, I got my report.
Just a moment.
Last
At page 95.
Pilot.
95. Yes.
At Baliguda, I got my report scribed. The scribe read over the report to me and finding it correctly written as per my instruction, I signed the report and submitted it to the police. I identified the dead body of the deceased at the hospital. Exhibit 10 already marked is my report. Exhibit 10/2 is my signature. Kindly come to previous PW 14, sir. Is the scribe. I do not know. May I please know that? I do not know Raghunath Sahu, Parapur, Lakshmanagar. OIC Sadar PS had handed over me 118 document, asked me to copy it out in another paper. Accordingly, I copied the document Exhibit 10. Is that document which I had scribed by copying it?
He is a hostile witness.
This is the genesis of the FIR.
He has stated about that as per the dictation.
The OIC.
No. Of previous statement was as per the dictation of PW 15. He scribed it and it was read over and explained to him. That has been brought out in confrontation part is there. So, but in the court,
all the same, he said that I do not know Raghunath Sahu.
Then
how it generated? That is also suspicious.
the circumstances which have been ultimately found out by the London trial court.
Only circumstance, suspicious circumstance that I did not report to the police. That much only boils down to it.
No, there was a torture twice. The matter was reported at the police station.
Might have been. But that is the cause for causing.
As stated by PW 15, the informant, father of the deceased.
But all other witnesses have said they are living happily, including their children.
Admittedly, PW number 15 has not stated about the case number that.
केस नंबर की से डॉक्यूमेंट मध्य प्रमाण है नहीं जो
case initiation of criminal proceeding twice against him and putting him behind bar, and he was being jailed out, bailed out.
Because they have brought the dead body from the house to the jungle. All through, whereas motionless, had there been any sign of leaving the person, if the person was leaving, they would not have cremated.
No,
nobody says that when the body was carried.
No, nobody has seen the body. In that light, nobody has stated that आमे body टाକୁ देखिथिलु ता देहरे कोनोसी क्षत चिन्ह थी बाकी अन्यान्य सेगुड़ा तो किछि नाही टोटल जे भी कहउचंती तनु डेड बॉडी टा को नेकिनी जंगल ले पोढ़ाइछि किंतु ये गोटे प्ली नेछि जे मु भी पढिली बट अन्य माने को प्रेजेंस रे पढली.
It was informed to the villagers. On the advice they have cremated.
किंतु डॉक्टर एविडेंस द्वारा सस्पिशियस होउची जे जो मुहूर्त रे पोड़ा हेइची से मुहूर्त रे तार जीवन थिला because soot particles had entered into the so
that might be possible, my lord. I cannot say.
No, that what you are telling that suppose she might not have died but might be lying as such and ताकू एमाने भाबिचंती यदि that is also possible जे ताकू then
and prosecution also has failed to prove, though PW 5, 6 and 25 were examined, that a vehicle was hired to carry that dead body, and the so-called 5 persons traveling in that vehicle includes that deceased. Prosecution has failed to prove.
Is lacking.
Chapter 22. Chapter 22. सेटा गोटे कुहा जे distinction between antemortem and postmortem bonds.
केते chapter
22 मोर पेज 631 अछि 23rd edition एटा अछि 27th edition
एटा भी 27 edition
medical legal aspect of bonds
page
631
631 631
Let's got is medical legal aspect of bonds. Distinction between antemortem and postmortem bonds. At times, the police remove the dead body while they act of burning in a cremating pyre to send the medical officer for postmortem examination when they suspect the dead body being hurriedly cremated to conceal the act of murder. In such a case, the medical officer should be prepared to tell the difference between antemortem and postmortem bonds. In case of death by bonds injury, there are three main points of differentiation between antemortem and postmortem bonds. प्रथम होची line of readiness, second होची vegetation, three होची reparative process. Line of readiness. तापर पृष्ठरे अछि line of readiness. In case of burn caused during life, a line of redness involving the whole true skin is formed around the injured part. It is a permanent line persisting even after death. But the redness of erythema, which is found beyond the line of redness due to distension is of capillaries, is transient, disappears under pressure during life and fades after death. The line of redness being vital function separates living from dead tissue and is often present in bone during life, though it takes some time to appear. It is, however, possible that it may be absent in case the person is very weak and tissue who dies immediately from the shock due to burns. ତାପରେ ହଉଛି vegetation. Vegetation ର ଅର୍ଥ ହଉଛି ଯେ ଦଉଛନ୍ତି ମାନେ the formation of vessels in the beneath of the skin. Google ତାର synonymous ହଉଛି blistering and vegetation caused by burn during life contains serious fluid consisting of albumin, chlorides, and often few poly poronuclear white blood cells, which has a red implanted base and raised papillae. The skin surrounding it is bright red and copper color. This is known through compared with false vegetations, which is produced after death. False vegetation contains only air but may contain very small quantity of serum compromising traces of albumin and chloride. Again, it is based on hard, dry, horny, and yellow instead of being red and inflammatory. Reparative process. Reparative process is such signs of inflammation, formation of granulation tissue, pus, and sloghs, which indicates that burns are caused during life. Burns caused after death shows no vital reaction have been dull white appearance with the opening of skin glands and colored gray. The internal organs roasted and emit a peculiar offensive odor.
Where is that about that soot particles?
Soot particles ଏନେ କିନ୍ତୁ ସ୍ମୋଦରିଂ ର ପୁଣି ଦେଇଛନ୍ତି ଯେ କଣ କଣ ଆସିବ ସେ ଯୋଉ କହୁଛନ୍ତି
presence of soot particles indicate that she was a type of she would ଏଇଠି ଆସିଲା ଏଇଟା ଅନୁପାତ ବାହାର କରିବ। She was burnt, she was alive.
And prosecution failed to prove that knowing that she is alive, she was put to death.
ସେଇଟା ଯୋଉଟା ଦରକାର ଜିନିଷଟା କାରଣ ୟାର ଇଏ ସମସ୍ତଙ୍କୁ କହିଛି ଯେ ଏଇ ଯୋଉ ପର୍ଟିକୁଲାର ଯେ ଡାଇରିଆ
Cause of death and died.
ହଁ that was the
Prosecution also has said that when she died in that particular place, instead of having her dead body to cremation ground, why it was taken to the jungle?
ତାଙ୍କର କ୍ରିମେସନ ଗ୍ରାଉଣ୍ଡ ଥିଲା କି ନଥିଲା
ସେଟା ପଚାରିଲେ cremation ground ଥିଲା କି
କ୍ରିମେସନ ଗ୍ରାଉଣ୍ଡ
ଯଦି ଥିଲା ତମେ ଜଙ୍ଗଲକୁ ସ୍ପେସିଫିକାଲି ତାକୁ ସେ ମନା କରି ରାଇଟ୍ ଷ୍ଟେଟମେଣ୍ଟ
ଗାଡି ତ ହେଲାନି ପ୍ରମାଣ ଅନ୍ୟ ସାକ୍ଷୀ ମାନେ କଣ କହିଛନ୍ତି ମିଷ୍ଟର ତ୍ରିପାଠୀ?
Yes, sir.
What the other witnesses have stated?
Other, all of them turned hostile.
ତ ଆପଣଙ୍କର ଏଇ ଯୋଉ ସେସନ ଜଜ୍ ଅଲ୍ଟିମେଟଲି ଯୋଉ ଇଏ ଗୁଡାକ କରିଛନ୍ତି ସର୍କମଷ୍ଟାନ୍ସ ଗୁଡାକ paragraph number 14.
Yes.
He concluded that these are the circumstances from which the prosecution has proved beyond all reasonable doubt. Let us come one by one. This accused Tuna habitually tortured the deceased, and on earlier 2 occasions, he had tortured the and deserted the deceased, and later, after compromising with the deceased, brought her back. Here only evidence
Yeah,
is
15,
the PW 15, the father of the.
1 and 2 are same, almost same.
Huh?
1
2টা ବି ସେମ୍ ଅଛି
କୋଉଟାରେ?
ସେଇ ରୋମାନ 2ଟା
jot down କରିଛନ୍ତି point ଗୁଡାକ circumstances ରେ
ହଁ
circumstances 1 and 2 almost similar.
no, see, the relevant witness is PW 15.
15, yes.
3 there is no evidence.
No,
Only
that is that
doctor.
suggestion given by the court, Roman 3. Then 4 ro jo evidence achuchi.
4, yes, he has asked for the help of the villagers. There is no one. He has admitted in the accused statement also.
Then 5, 6 ଏଇଗୁଡାକ କିଛି ଆସୁନି ଯେ
ନା
It has that this was made unconscious.
ଡକ୍ଟର କୋର୍ଟର ଯୋଉ
କୋର୍ଟରେ ପଚାରିଥିଲେ ତାକୁ ସେଇଟା
ସେଇଆକୁ ନେଇଗଲା substance. So that is not the. As if somebody has stated like that. So how, Mr. Tripathi, you say that when so far as the circumstantial evidence, that principle, 5 golden principle,
no.
punch seal, that it should be, a chain should be so complete that
Other hypothesis.
it will only point out towards the guilt of that other things are completely ruled out.
Yes.
ଏଠି ଆପଣ first one by one ଆପଣ ଆସନ୍ତୁ ପୁଅ ଝିଅ ଯୋଉ 2 ଜଣ ଏକ୍ସାମିନ ହେଲେ ଝିଅ ହେଲା PW1 ପୁଅଟା ହେଲା କେତେ ନମ୍ବର ସାକ୍ଷୀ?
PW 24.
24.
Just a minute.
Is 117.
Huh. My father and mother were living well. तो पुओ झियो 2 जण जा कहउछंती हम बापा मां भलरे रहउथिले गला बाकी previous dispute विषय only witness is
15.
PW15.
Yes, obviously.
কিন্তু
No,
admittedly
no document
no
was.
document has been proved. এই ଯୋଉ ବେଲ୍ ରେ ଯାଇଥିଲା ବେଲ୍ ରେ ଆସିଲା ସେ ଅର୍ଡର ମଧ୍ୟ କିଛି ପ୍ରମାଣ ହେଇନି। His father being interested witness. So PW15
after coming to the crime, concealed it and committed by him. Why should inform the villagers to help him?
ଏଠି conceal ତ କରିନି ତ ସମସ୍ତଙ୍କୁ ଡାକିକି ନେଇକି
If their intention is to for the crime,
No.
he should not have consulted the villagers and called them to help it. Straight away hiring a vehicle.
Another thing which is striking that why the dead body was not sent to the taken to the cremation ground, why it was taken to the jungle and
Yes.
but again the material is missing from record that for that village there is any cremation ground or not.
That was not a cremation ground.
Huh?
Place for cremation.
Huh.
So where the body was cremated, that is not
ସେ evidence ନ ରହିଲେ ଜଙ୍ଗଲ ଭିତରେ ମନେକର ଜଣକୁ ପୋଡି ଦେଇଛନ୍ତି ଆପଣ ଯଦି କୌଣସି ଗାଁରେ ଯଦି ହଁ ସ୍ପେସିଫିକ ଗୋଟେ ଥିବ ଯେ ଏଇ ଜାଗାରେ ପୋଡା ହବ ସେଠି ନ ପୋଡିକି ତାକୁ ନେଇକି କୋଉ ଜଙ୍ଗଲ ଭିତରେ ପୋଡିଦେବେ that would
That
create
to 15 kilometers away.
କୋଉଠି
ତାଙ୍କ ଘରଠୁ।
Prosecution has failed to prove.
No, ଆପଣଙ୍କ କ୍ରିମେସନ ଗ୍ରାଉଣ୍ଡ ନାହିଁ ଯଦି ଏମିତିଆ ଏଭିଡେନ୍ସ ନାହିଁ କଥା ହଉଛି ଦେନ୍ ଆପଣ ହୁଏତ କୌଣସି ଅନ୍ୟ ଜାଗାରେ ପୋଡି ପାରନ୍ତି ତେଣୁ କୋଉଠି ପୋଡିବେ
ସେଇଟା ତ ତାର 313 ରେ ନାହିଁ କହୁଛି ଆମେ ପୋଡିଦେଲୁ ଆଉ ଗାଁରେ ପୋଡିଲୁ। କିନ୍ତୁ in fact that is 15
of the relations.
Yes.
His relatives.
Yes, but in fact that is 15 kilometers away from
who has
that.
stated that
Yes, there was
about the distance from that.
That is in the evidence of 22. The relation of the deceased.
How he is related?
Sunita is my paternal aunt.
All right, so କଣ କହୁଛି?
Yes,
Uttarangad, which is situated, acha, police showed me the dead body which was burnt in village Budulipur.
Near village.
Near village. Uttamgad, which is situated at a distance of 15 kilometers away from village. I could not identify the dead body. Police held inquest over this one. So
that is a distance from his village, her village, my village. Tumuli.
ଏମାନେ ରହୁଥିଲେ କୋଉ ଗାଁରେ କି?
ଏମାନେ ରହୁଥିଲେ
ନାଇଁ
ଦୁବାଗଡ଼।
Right. Started staying at Dubagad. Living at. So ଆମର ଦରକାର ଯେ ଦୁବାଗଡ଼ରୁ ଯୋଉ ଜାଗାରେ place of that cremation.
Yes.
ହେଲା that you said that it was 15 kilometers. Who has stated?
That is not there.
Not there.
It is the distance between the village of this witness PW22 and the place.
No, that is not relevant.
15 kilometers away from my village.
ସେଇଆ କହୁଛନ୍ତି।
That's not relevant.
ତାର ଭିଲେଜ ହଉଛି ତୁମଡି ବନ୍ଧ ଯୋଉଠି ଆଗେ ଏମାନେ ରହୁଥିଲେ।
Yes.
ଏମାନେ ପ୍ରଥମେ କୋଉଠି ରହୁଥିଲେ କି? ବାପା କହୁଛି
ବାହାଘର କେତେ ବର୍ଷ ପର୍ଯ୍ୟନ୍ତ ଖୁସିରେ ଚଳୁଥିଲେ କହିଛି ବାପା ବି।
They are staying at Tumudi.
କୋଉଠି?
After the marriage, PW15. After the marriage, this is stayed at the house of Aki, Pune, situated at Tumudi.
ବାପା
ଏଇ ଯୋଉ ତୁମଡି ବନ୍ଧଟାରେ ହଉଛି ଏଇ ଲୋକଟା ରହୁଛି PW22 ରହୁଥିଲା। ସିଏ କହୁଛି ଯେ ଆମ ଗାଁ ତୁମୁଡି ବନ୍ଧରୁ ଯୋଉ ଗାଁରେ ଯୋଉଠି ଡେଡ ବଡି ମିଳିଲା ସେଇଟା ହଉଛି 15 କିଲୋମିଟର। କିନ୍ତୁ ଏମାନେ ତୁମୁଡି ବନ୍ଧରେ ରହୁନଥିଲେ ଏମାନେ ତୁମୁଡି ବନ୍ଧରୁ ଯାଇକିନି ଦୁବାଗଡରେ ରହୁଥିଲେ। So is there anything from to show the distance between Dubagad to that place of से जो जगह रे पोढ़ा हैतला सेटा को जंगल गोटे कोन कहउछंती पी आयु आदर किए
I ହଉଛି PW7
7919
PW15 ବି କହିନି ଯେ ତା ଝିଅକୁ କଣ ପାଇଁ ସେ ନିର୍ଯାତନା ଦେଲା ପରେ though he has stated in the FIR that after their marriage they were living happily.
three investigating officers. One is PW7,
9 and 19.
PW9 and PW19 आयु ए जो स्पॉट को किए जाइथरा भितर को
PW7 at para 7.
पारा 7 पेज 79 कथा को
Yes,
हां कोनटा अछि त देई
I had examined Siddheswar Machi PW2
ता स्टेटमेंट टा को
ସେଇଟା ସେମିତିଆ ସବୁ କହିଛନ୍ତି ସେ ଆଇ ଗୁଡା ଆଉ କିଛି ନିଜ ମନରୁ କିଛି କହିନା
नहीं स्पॉट को ये पर जाइथला स्पॉट टा कोटा को जगह रे I was attached to so and so on that day took up inquiry someday I examined so and so I examined this held the inquest.
Okay. The Bhuji was lying in a top confluence inside so and so jungle. Paragon. K70. And that's the essential position.
Okay, that would be you see this police station where the FIR was lodged is Sadar Fulbani. Eta hochi तुमड़ी बंधरु डिस्टेंस टा केते सेठी की सेमति किछि नाही
Concept to guard.
As per 22, Tumudiband and the place of occurrence is 15 kilometers. But the that is Budlipada. The half-bound condition, the dead body was lying in the half-bound condition inside the Budlipada. The that place.
So living happily one PW1 then PW तारा डॉक्टर टा हला PW20 केते कहले
24 is
Son. PW1 is the daughter.
अच्छा ये हला डॉक्टर ये हला सन
others are also stated so.
and बापा ମଧ୍ୟ कहूची जे that is PW
ଖୁସିରେ ଚଳୁଥିଲେ ଏବଂ ତାଙ୍କ ଓରସ
sometime
12 ବର୍ଷ 10 ବର୍ଷ ଝିଅ 5 ବର୍ଷ ଜନ୍ମ
3 and 4 also said.
12-13 ବର୍ଷ ପର୍ଯ୍ୟନ୍ତ ଖୁସିରେ ଚଳୁଥିଲେ ଇତିମଧ୍ୟ ସ୍ୱାମୀ ନିର୍ଯାତନା ଯୋଉ କଣ ପାଇଁ ତାଙ୍କୁ ନିର୍ଯାତନା ଦଉଥିଲେ
ଏଗୁଡା
ଡାଉଟ୍
ନାହିଁ
କଣ କିଛି ନାହିଁ no reason.
no evidence So if this is the nature of evidence, how you will establish a case under 302? All right, take down. JCRLA number 37 of 2009 and CRLA number 37 of 2009. जोटा ये रहिला ताधे 4 वर्ष तंगर कंफ्यूजन हाँ से जो नाही मटेरियल किसी ना एंकर सी गोटे ऑर्डर ହେଇଛି ଯେ मिस्टर P.S. Das Parida to argue Pradir Mandam, Mr. D.P. Das Guru Maharaj, first counter. No, that his name, your name will be top and will be, his name will also be there. Both the names will be there. The appellant Tuna Sahu in JCRLA number 37 of 2009 and the appellants Kunna Sahu and Rajakishore Sahu alias Raju in CRLA number 37 of 2009. गोटे हूँ नंबरटा सेम गोटे हूँ जेसीआरएल जड़े आउ एथे रोचंदी दी जण हैला
CRL record टा
Case trial in the court of London Session Judge Bulbani in ST case number 80 of 2007 for offences punishable under section 201 and 202 of the Indian Penal Code. On the accusation that on what is this date mentioned in the charge? Page 48. सेमती तो किसी यही नथिला कारण डेट ऑफ ऑकरेंस आज आसुची not noted as report is 1/3/2007 21/2/2007 रे ना 21/2 था पूर्व पेज रे 302 रे 21/2 लिखा है ओ हेला सेटा कर दियो 21/2/2007 knowing or having reason to believe that the offense of murder has been committed cause certain evidence connected with the said offense, that is dead body, to disappear with intention to screen appellant Tuna Sahu from legal punishment. And omitted to give information respecting to commission of offense which they were legally bound to give. ता पूर्वरु लिखिबो गोटे प्रथम आगे लोक the appellant Tuna Sahu was charged under section 302 of the Indian Penal Code on the accusation that on 21/2/2007 at village Dubagada, he committed murder of Sunita Sahu, bracketary hereafter the deceased. है ना तापर लिखिबो the appellant से जोटा डाकिल है ना प्रथमे 302 पर से दिटा the London trial court found the appellant Tuna Sahu guilty under section 302, 201 and 202 of the Indian Penal Code and sentenced him to undergo imprisonment for life and to pay a fine of ₹1,000 in default to undergo RI for 6 months for the offence under section 302 IPC. RI for 4 years. That is against all. Acha. All the three appellants were sentenced to undergo RI for 4 years and to pay fine of rupees 1,000 in default to undergo RI for 6 months for the offense under section 201 of the Indian Penal Code, imprisonment for 3 months for the offense under section RI for 3 months for the offense under section 202 each कर देवे है ना और से जो फाइन टा करिवे सेटा मध्ये each करिवे in default है ना alright. The substantive sentences were directed to run concurrently. As for the first information report, bracket exhibit 10, lodged by S.K.SAHOO, bracket PW 15, the father of the deceased, on 1/3/2007, before the officer in charge, Sadar Police Station, Fulbani, is that the marriage between the appellant Tuna Sahu and the deceased was solemnized 14 years prior to the date of lodging FIR. And the couple were living happily and they were blessed with 2 sons and 1 daughter, who are aged about 12 years, 10 years, and 5 years, 8 years, respectively. It is further stated that appellant Tuna Sahu tortured the deceased, for which a case was instituted against him in the year 2003. And the appellant was arrested and forwarded to court. While the case was sub judice, the appellant and the deceased were staying in village Dumuriwan. Again in the year 2005, when the deceased was subjected to torture by the appellant, the deceased instituted another case in Dumuribandha police station. It is further stated in the FIR that 2 months prior to the date of lodging of the FIR of this case, there was amicable settlement between the appellant and the deceased in Berhampur court, and they stayed together in village Dubagar. On 27/2/2007, the informant bracket PW 15 came to know from one of his relatives that the deceased was killed and her dead body was thrown in Dumudiband jungle by carrying it in a vehicle. The informant proceeded to village Dubagar and found the deceased was absent. And after ascertaining from the locality that the dead body of the deceased had been taken in a jeep to Kurtamgarh, PW-15 went there and found that the dead body has been burnt inside the jungle in village Budulipadar, which is situated closely to Kurtamgarh. And Dumudiband police reached at the scene of occurrence. अच्छा, threw the dead body inside the jungle. The informant suspected that the appellant had killed the deceased on the basis of such FIR. Fulbani Sadar PS case number 15 dated 1/3/2007 was registered under section 302(201) by 34 of the Indian Penal Code against the appellant S.K.SAHOO. Stop. It further appears from the evidence of PW7, the officer in charge of Tumudibanda police station, that on the basis of a written FIR lodged on 23/2/2007, Fulbani Sadar PS UD case number 2 of 2007 was registered, and he took of inquiry, and during course of inquiry he examined the witness, examined the informant, and sent a constable to guard the dead body. And after reaching at the spot where the dead body was lying in half-burnt condition, inside Budulipadar jungle, he held inquest over the dead body and sent the dead body to SD Hospital, Baliguda for post-mortem examinations. Hmm.
Describe the
Hmm.
Sahu, PW14. Lecture was also described.
No, I see you have written a written report, which is like the which was scribed by PW14 Dutti Krishna Sahu. है ना? PW19 was the officer in charge of Sadar Police Station on 1/3/2007 when the case was registered and on the report of PW15, and he took up investigation of the case, examined the informant and other witnesses, visited the spot, seized household articles as per seizure list, household articles of the deceased as per seizure list exhibit 8, and also seized one motorcycle from Vishwanath Sahu as per seizure list exhibit 7/2. He forwarded the appellant Tuna Sahu to court on 5/3/2007. The appellant Rajkishore Sahu was arrested on 6/3/2007 and was forwarded to court. The commander vehicle was seized from the possession of Sunil Kumar Mohanty, Anil, Sunil, Anil Kiye, Anil Kumar Mohanty bracket PW6 as per seizure list exhibit 6/2, and it was given in a Jimma as per Jimanama exhibit 2. The motorcycle was also left in the Jimma of Raju Sahu. As per seizure list, as per Jimanama exhibit 11. On 1/7/2007, PW19 handed over charge of investigation of the case TO2 Lakshmidhar Mahapatra bracket PW9 who on completion of investigation submitted charge sheet. After submission of charge sheet next para, the case was committed to the Court of Session. Complying due procedure where the Lennon trial court framed charges as aforesaid, and since the appellant pleaded not guilty and claimed to be tried, the sessions trial procedure was resorted to establish their guilt. In order to prove its case, the prosecution examined 26 witnesses. Prosecution also proved 10 documents, 10 na 11, 11 documents. The defense plea of the appellant Tuna Sahu is that is one of denial, and it is stated that he, along with the deceased, were staying in village Dubagad, and the deceased died on account of diarrhea. And since the villagers of Dubagad so also his friends and relations told him for cremation of the dead body, the same was done in village Dubagad. The Lennon trial court, after assessing the evidence on record, came to hold that the prosecution has established the following circumstances to prove the case against the appellants, which are as follows. Page running page huchi 33 and 34. जो circumstance, 7टा circumstance अच्छी ताकि note down कर. Accordingly, the appellants were held guilty of the offences charged. Mr. D.P. Das, Lennon counsel, appearing for the appellant, so also the Lennon amicus curiae, Mr. B.S. Das Parida, was engaged by this court for the appellant Tuna Sahu, and since he was also appearing for the appellants Puna Sahu and Rajkishore Sahu alias Raju in CRLA number 37 of 2009, contended that the circumstances which has been noted by the Lennon trial court in paragraph number 14 of the impugned judgment have not been proved, and the circumstances have not been established firmly, and it do not form a complete chain so as to come to irresistible conclusion that it is the appellant and appellant alone who has committed the crime, appellants who have committed the crime. and cause disappearance of the evidence or give false information and omitted to give information, intentionally omitted to give any information respecting to the offense to whom they are legally bound to give. And therefore, it's a fit case where benefit of doubt should be extended in favor of the appellants. Land counsel for the state, on the other hand, supported the impugned judgment and argued that all the 7 circumstances enumerated under under paragraph 14 of the impugned judgment have been clearly proved by the prosecution, and they do form a complete chain which point towards the guilt of the appellants. Adverting to the contention raised by the learned counsel for the respective parties, and coming to the nature of death of the deceased, we find that the doctor bracket PW8 who conducted postmortem examination over the dead body of the deceased on 24/2/2007 at SD Hospital, Baliguda, stated that he noticed the following injuries. Page number 80 रे देखिएगा ना, या अच्छी से.
So the question also proves that all the questions are set by the thinking that the deceased was dead. So it cannot be that when that she was alive, she was.
एटाକୁ paragraph 2 ଟା करिए, ताପରେ paragraph number 3 ହେଲା, and he has proved his report exhibit 5 and further opined that the injuries are antemortem in nature. The court has put a question to the doctor and the doctor has stated as follows. See you two quote जोटा अच्छी page 81 से सेटा quote कर दे, inverted comma भीतर रख दे. From the medical evidence, the appellant has taken a specific plea that on account of the death of the deceased due to diarrhea, as per the advice of the villagers and the friends and relatives, accused statement as per the advice of the villagers and in the company of his friends, his well-wishers, relatives, and he the dead body was cremated. Not a single witness has stated to have seen the dead body and noticed any kind of external injuries on the body of in the body. तो some किए कहला था जो ये कुनै पुलिस स्टेशन दबाको जोटा कहले
PW3.
PW3 Though PW3 has stated that when appellant Raja's wife came and informed him about the death of the deceased, he advised her to report the matter to the police, and he also advised the appellant Tuna to report the matter at the police station. But the dead body was disposed of before arrival of the police. But he has stated in the cross-examination that he had not seen the dead body. Therefore, there is no clinching material available on record that the death of the deceased was homicidal one, or there was she made an unnatural death. And on the basis of the doctor's evidence to the question put by the court, the London trial court aid in holding that circumstance number 3 has been proved. That is, the deceased was made unconscious by pressing her nose and mouth by a pillow, and thereafter a message was spread in the village that the deceased died of diarrhea and that the dead body was not shown to anybody, including her own daughter, bracket PW1. It appears from the evidence that the intimation was given to the villagers about the death of the deceased, and thereafter the dead body was burnt. The dead body was cremated. Therefore, one of the vital links in the prosecution case, as held to have been proved by the London trial court, is missing in this case. The circumstance that the appellant Tuna was habitually torturing the deceased, and on earlier 2 occasions he had tortured and deserted the deceased, and later compromising with the deceased brought her back, is deposed to by only one witness, that is the father of the deceased, PW15. Who is also the informant in this case. But it appears from the evidence of the daughter PW1, the son PW24 of the appellant and the deceased, that that both of them were living happily. Even PW15 has stated that P2 15 to which coin? Even PW3 ta dekho. ଆଉ କିଏ ଗୋଟେ କହିଲା ଯୋଉ ଅଲରେଡି ଚଳୁଥିଲା ବୋଲି ସବୁ advised to answer. Oh, okay. PW3 has stated, PW3, who is the house owner where the appellant and the deceased were staying in village Dubagad, have stated that they were found in all happiness. PW4 has also stated that the deceased was pulling on well with her husband, that is Tuna Sahu. Though PW15 stated about lodging of the first information report twice by the deceased and about the arrest of the appellant, but neither he has stated about any case number nor any documents relating to institution of case has been proved by the prosecution. Therefore, we are of the view that the prosecution has failed to establish the circumstance number 1. Similarly, so far as circumstance number 2, as mentioned in the impugned judgment, that appellant number that the appellant Tuna Sahu brought the deceased from Tumdi Bandha to Dubagad, where they stayed in the rented house of PW3. And that he had stated before PW15 that he would stay in at Fulbani, and thus he wanted to keep it a secret of his place of residence from the in-laws, is only deposed to by PW15. As already discussed in the heading of the previous circumstance number 1, that there is no clinching evidence that while the appellant and the deceased were staying in the rented house of PW3, there was any kind of torture or cruelty given to the deceased by the appellant. We are of the view that the prosecution has failed to establish any motive on the part of appellant Tuna Sahu to commit the crime. The next circumstance, that is circumstance number 4, is that the appellant Tuna Sahu asked for help from the villagers of Dubagad for cremation of the deceased, and villagers suspected foul play and advised the appellant Tuna Sahu to report the matter to police and also sent message to parents of the deceased. In this respect, the relevant witnesses are PW3, PW4, and PW10. PW3 has stated that he was given intimation about the death of the deceased by appellant Raja, wife of appellant Raja, to whom she advised not to report to report the matter before police. And when wife of Raja further asked him to provide firewood for cremation purpose, he advised her not to dispose of the dead body. The wife of Raja has not been examined in this case. The PW3 further stated that he had also given advice to appellant Tuna to report the matter in the police station, but the dead body was disposed of before arrival of police. When there is absence of any material that it was a homicidal death or it was an unnatural death, and it is the defense plea that the deceased met a natural death and died of diarrhea merely because the advice which was given by PW3 to report the matter at the police station was not acted upon, it cannot be said that this is a clinching circumstance against the appellants. The next circumstance, as has been held by the London trial court to have been proved, is that the appellants Tuna Sahu and Rajkishore Sahu alias Raju in CRLA number 37 of 2009 came to Fulbani and brought the commander-chief of PW6, which was driven by PW5, and in that jeep, in the night of 22 to 2007, the unconscious body of the deceased was shifted from the rented house of appellant Tuna to the jungle situated near village Buduli Padar. In this respect, the evidence of PW5 and PW6 are relevant. However, it appears from the evidence of PW6, the owner of the commander jeep, that on 22 to 2007, all the three appellants came to Fulbani and contacted him to hire his vehicle for their journey from Fulbani to Tumudibandha via Dubagad. And he agreed to give the vehicle on hire, and the driver, bracketary PW5, took the vehicle. but he stated that he did not know what happened thereafter. He again said that appellant Tuna had not come with the other two appellants to contact him. Similarly, PW5, the driver of the jeep, has stated that appellant Raja hired the vehicle and from his house in Dubagar, he took Raja, Kunna and other family members, all numbering 5, to the vehicle and came to Tumriband. And they got down there and he drove the vehicle back. In the cross-examination, he has stated that he was never approached by any of the appellants or their relatives. No, it cut it. From the conjoint reading of PW6, the owner of the commander jeep and the driver PW5, it doesn't appear that uh, it, that the jeep was utilized for shifting the unconscious body of the deceased from the rented house of the appellant Tuna Sahu to the jungle situated near village Uduli Padar. We are of the view that the findings arrived by the London trial court is an error of record. Finding arrived at basing on the evidence of PW5 and 6 is an error of record. Coming to the next circumstance, that is circumstance number 6, that appellant Tuna approached PW25, a villager, to help him in disposing of the body of the deceased and told him that the deceased died of diarrhea and that the body of the deceased was in the commander jeep. We find that PW25 has been declared hostile. And after being in the cross-examination by the prosecution, he has stated that on 23/2/2007, at about 12 midnight, the appellant Tuna informed him that his wife had expired due to diarrhea and asked him to assist for cremation of the dead body. And he told him that the dead body of the deceased was inside the commander vehicle. However, since from the evidence of the driver of the commander jeep, there is no such material available that any dead body was kept in his vehicle to be carried for cremation. We are not inclined to place reliance on the evidence of PW 25, and we are of the view that this circumstance number 6 has also not been proved by the prosecution. Coming to the last circumstance, that the deceased was burnt alive, causing her death at about midday time on 23/2/2007, and her body being burnt was recovered from the jungle. Though from the PM report, which has been proved by the doctor, and in view of the presence of black particles of soot mixed with mucus in the internal layers of trachea and air passage, the it can be said that while the deceased was burnt, he was still breathing, but the in absence of any other clinching evidence on record, and when it is the defense case that it was a case of death by death on account of diarrhea, and the dead body was taken as per the advice of the villagers, and in presence of the relatives and family members, the dead body was cremated, comma, the these circumstances alone cannot establish that the appellant Tunasau has committed the murder, and knowing that the knowing or having reason to believe that an offense has been committed, they have caused any evidence of the commission of offense to disappear, comma, with the intention of screening them from legal punishment, or that they intentionally omitted to give any information respecting that offense which they were legally bound to give. Law is well settled that heinous the crime, higher must be the proof, and suspicion, howsoever strong, cannot take the place of proof. When the prosecution has failed to establish that it was a case of homicidal or unnatural death, and that the appellant Tuna Sahu was responsible for such death, and all the three appellants knew that an offense has been committed for which they disposed of the dead body by burning it. And there is absence of any motive behind the commission of the crime. And the finding of the Lenin trial court that the circumstances have been proved against the appellants either based on no evidence or it is an error of record. We are of the view that it's a fit case where benefit of doubt should be extended in favor of the appellants. Accordingly, the impugned judgment of conviction of the appellant Tuna Sahu under section 302/201 and 202 of the Indian Penal Code. So also the appellants Tuna Sahu and Rajkishore Sahu alias Raju under section 201 and 202 of the Indian Penal Code are hereby set aside. It appears that the appellants Tuna Sahu and Rajkishore Sahu were directed to be released on bail by this court as per order dated as per the order dated 2/2/2009. Similarly, the appellant Tuna Sahu was directed to be released on bail as per order dated 25/2011. The appellants were discharged from the liability of their bail bond. The surety bond stood cancelled. Put a note of appreciation on the efforts of Mr. D.P. Da. Okay, Mr. D.P. and also the learning Mr. Tripathi.
One jail criminal appeal also has directed me to appear. It's item 13. I only need 2 more days. Actually, supposed to be listed.
No, this week there will be, today is the last day, so you have to prepare for the next week. What is the problem?
Thursday or Wednesday.
Let it come, we will see that. We want an appeal and they are also assisting us, the state councillor, so that was enough.
Left out matters will be listed next
Like
week.
Wednesday.
I pray for Monday, Your Lordship.
The petitioner Cecil Minor and lost to second year student. Garden matter minute, he will appear the this month.
Bail matter. Give it.
Jail criminal appeal minor. Jail criminal appeal.
For?
I filed the IA for bail.
Pardon to mention, my lord, on CRLA 466 of 15, my lord, the period of conviction already undergone by the appellant, my lord. Another for bail.
Bail matter.
Give it.
My lord, bail matter. The petitioner is in custody since 2 years. My lord, this matter has come up 3 times but did not come.
Will come next week.
And I may pardon mention, my lord. One criminal appeal, case admission, 4 years conviction, he was
Yes.
on bail during trial. Another, my lord, out of 10 years is more than custody 6 years.
Will come next
Your
week.
lordship, this matter, your lordship had earlier granted her bail, but she was unable to furnish cash security. Now she's in a position to do it. Your lordship had earlier ordered this to be taken up in January, but did not reach and did not taken up in the list.
Give it.
Pardon to mention, my lord, appellant filed the interlocutory application, his daughter suffering from cancer.
Give it.
Another is the tired up bail matter.
Give it.
Serial number 950 of 2023, lordship. Lordship, out of 10 years of sentence.
Give it. Give it.
Another is criminal revision fresh admission under Juvenile Justice Act. Lordship.
To enter application on the ground of illness of the petitioner. Today in the last 4 days. Where they mentioned please make it better today. Kindly take it up in case it doesn't reach.
All right.
Before the lordship line.
Yeah.
30 seconds.
Supplementary list item number 1.
Item number 1, you'll also have to glance the order at 19/5/2022, my lord. Order number 3, para 4. After going through the documents annexed to the initial bail application, the petitioner is directed to appear before the IO on 25/5/2022 and shall cooperate with the investigation and shall further appear before the IO as and when required to that effect. Written notice in writing shall be handed over to him in advance. And to my instruction, he has once appeared, subsequently. And my learned state was likely to obtain instruction with regard to whether any notice was issued for his appearance or not. That is what.
So now the charge sheet has been submitted.
Yes.
So you are shown as an absconder. So, and the further mentioned that you have never appeared before the holding IO nor extended any cooperation. So you surrender and move for bail. You are given an interim protection, and if you flout the order of the court, then what can be done?
My privacy, keep it in Monday.
No, this is the report.
Yes.
Once the superintendent,
no, I've got. Yes.
Superintendent of police report indicates that you are not cooperating. You are not carried out the order. So why liberty will further? You have already enjoyed the liberty for almost 2 years because the first order was passed on 19/5/2022.
Yes, 95.
So,
in fact, I am the person at my instance that FIR was registered because there is illegal mining in the area.
The petitioner.
And almost all the co-accused person granted bail except the petitioner.
That you surrender and move for bail. I am observing that as per the order dated 19/5/2022, the petitioner was directed to appear before the investigating officer and to cooperate with investigation, with a further direction to appear before the IO as and when required. The petitioner was granted interim protection. Today, the London Council for the State has produced written instruction dated 19/1/2024 from Superintendent of Police STF CID CB Bhubaneswar to the effect that not only charge sheet has been filed, but the petitioner has not appeared before the holding IO nor extended any cooperation.
I'm sorry. Once I have appeared on 25/6, I have got the document.
Yeah, report ta jaha lekha hai mu seya poduchi.
Say SP SDF need sign ko ଦେଇଛନ୍ତି.
As per the order of this court dated 19/5/2022. Learned counsel for the petitioner submitted that the co-accused persons have been released on bail. In view of such submission, while not inclined to grant anticipatory bail to the petitioner, in case the petitioner surrenders before the learned court below within a period of 4 weeks from today, case court na de debe SDGM Khurda in GR case number so and so arising out of so and so, and moves an application for bail, the same shall be disposed of expeditiously, preferably in the first hour. And claim of parity is to be taken into account. In the event in order to enable the petitioner to move the higher in case of refusal of bail, and in such event, the higher court shall dispose of the bail application expeditiously.
Pursuant to the order in 19/5, appeared on 25/5. The SPIO himself has.
The Learned Counsel for the petitioner, however, se jo report ta pore lekhibe, however, submitted that in pursuance of the order dated 19/5/2022, the petitioner has once appeared
on 25/5/2022
investigating officer on 25/5/2021.
22.
22.
Yes,
22/5/2021. All right. Yes, next. Dispose of it.
Item number 2. Made please your lordship. My lord, here the genesis of the allegation, my lord. This was before your lordship previously. The genesis of the allegation, my lord, may I submit?
Yes.
That petition number 1 is the managing director of Brahmani Engicon Private Limited.
Yeah.
And petition number 2 is another director who happens to be the son of petition number 1. My lord, the allegation in the FIR is that the informant withdrew from the directorship on 4th of February 2020. And thereafter, he alleges that the managing director, though he was continuing as authorized signatory to withdraw from the bank matter, the managing director opened another bank account in the name of the company, and they are engaged in the construction projects matter, and received rupees 50 lakhs, about rupees 50 lakhs, and out of that he has transferred the siphoned away matter 26 lakhs of money matter. That is the allegation.
26 lakhs transfer to which account?
My lord, my case is I have filed the bank documents matter. It has been paid to the creditors matter. The documents have been filed in my bail application matter. Your lordship kindly come to, it has not gone to my personal account.
Okay.
It has gone to the creditors matter. 24 lakhs is still in the account matter, which has been seized matter. Your lordship kindly come to page 23 matter of the bail application.
Just a minute. Mr. Patnaik, just a minute. In the FIR at page 13, the last paragraph reads like this, that Mahapatra, father and son, have tried to mislead all the government officials and company debtors to bring all the receivables of the company to the said unauthorized account, and have also succeeded. It is worth noting that Sudhanshu Sekhar Mahapatra and Abhishek Mahapatra together have brought a payment of the company from the office of Superintendent Engineer R&B Raurkela Government of Odisha amounting to rupees 50,66,302 to the said unauthorized account, and by providing unauthorized bank documents of ICICI Bank to so and so.
That's
As
not
the
done.
company involves in the construction business, all the vehicles so and so of the company are forcibly occupied so and so. So do you mean to say?
Genesis of the allegation is 26 lakhs have been siphoned away from the government, received from the government, my lord, about 50 lakhs, my lord. And the bank account, my lord, has been given at page 23. Your lordship kindly see. Because, my lord, preceding to the FIR, my lord, the informant asked me to give him to rupees 20 lakhs, my lord. That WhatsApp message I have filed also with the application. And after that, I said that 20 lakhs is not possible, only 15 lakhs will be possible. Then, my lord, he has filed the FIR. That's my allegation, my lord. WhatsApp message, my lord, is at page 18 and 19, my lord.
No, what about this page 23 you are pointing out?
Yes, my lord. As has been paid to the creditors.
Okay.
That synopsis is there, my lord, of the ICCI Bank. Because he is the authorized signatory, my lord, informant. He did not cooperate with me.
Okay.
And I have opened another account in the name of the company. That is also his allegation. Your lordship
So,
kindly.
whether the misappropriation amount is rupees 50 lakh and odd, or it is
No, my lord.
lakhs.
24 lakhs is in pending in the account, my lord. That calculation I have.
So what is your just a minute, Mr. Patnaik? Yes, is it correct that though in the first information report it is mentioned that the amount which was received is 50 lakhs and 66,000 and odd, that in that very account 24 lakhs is still there, and so far as the rest amount of rupees 26 lakhs is concerned, that has been given to as per that page number kete jo place korthile 23 na. So different creditors, who are they, Mr. Patnaik? They are the
My lord,
the amount which you have paid to different persons. Who are they?
They are given, my lord, in the page 23.
Yes. Who are they? Why the amount was
They
paid?
are the creditors of the company, my lord.
Okay.
They have supplied
Right.
materials have not been paid. Your lordship would kindly see in the FIR, he has mentioned 26 lakhs at page 13, my lord.
FIR 20.
Page 13, my lord. Last but one para. My lord, he has said that 26 lakhs have been
managed to
imbibe.
So what is the correct position?
Detail
My
investigation.
lord, page 23.
So far.
And petition number 1 has appeared 6 times, my lord, before the IO, as per your lordship's direction.
Okay.
Previously, this
Page 23 your
petition
lordship
was rejected by this honorable court, because he was not cooperating with the investigation.
No, now,
now he is also not cooperating. The IO several times have issuing letter to produce the relevant document which was forged. He is not filing the.
No. But what Mr. Patnaik has just submitted, you must have heard that at least on 6 occasions, on being noticed, the petitioner has appeared. Whether it
yes, appear, but he has not given anything.
No, giving anything means what?
Which documents the IO needs, that is with him, and he is not producing it.
Your lordship's last order kindly be seen. 28/7/2023, my lord. That was the subject matter of dispute. I said, your lordship kindly come to page 2 of the order, my lord.
Yes.
the Raghunathpuri police station stated that he has taken over the charge of investigation of the case and he requires the resolution copy in which the accused Abhishek Mahapatra has been appointed as director of the company, namely Brahmani Engicon Private Limited, as it is the case of the informant that the signatures appearing in the said resolution are fake. How could you know? We don't know. Mr. Patnaik submits that he wants to obtain instruction from the petitioner relating to availability of such resolution copy with him, and if it is available, he will produce it before the inspector in charge on or before 5th August 2023. Your Lordship would kindly see I have filed the affidavit saying that the office is under lock and key by the informant, my lord. Your Lordship kindly see my affidavit filed on 4/8/2023. Your Lordship got it?
Yes, that is filed by Sudhanshu Shekhar Mahapatra.
Yes, my lord. Your
Yes.
Lordship is right.
Have you got
Your
that
Lordship
affidavit?
kindly come to internal page 2.
Mr. Patnaik is referring to. Please come to that affidavit. The date is 4th August 2023. You are for the informant.
Informant, yes, Your Lordship.
Have you got that affidavit?
No, Your Lordship, that is not available with me.
No, I have served. I have not served.
The earlier memo is there, the bunch of
No,
documents.
this is a document, this is an affidavit which is dated 4/8/2023, in which it is mentioned, Mr. Tripathi,
Yes, my lord.
in that it is very well mentioned that the intimation has been given to IIC Raghunathpuri police station that these are the documents which are not available with him, as because ICICI Bank freezed by banker as per the direction and application made by Kamalpat Dalmia, and rest other documents are available in the office. Then submitted another letter to IIC on so and so, that today I am submitting the copy of the same for your kind perusal. The order, other relevant documents as required by you are not available with me, as the office so and so is lock and key of the office, and all the documents such as computers so and so are in the custody of ex-director. So what is your instruction? He has stated that this is the difficulty for which I could not, some documents are not available with me.
Kindly have a glance to my affidavit.
Yes.
25/4/23. At para 4, Miller.
Yeah.
That both instruction was already submitted with the Lordship, correct? After going through the all material record as per the requirement of such material documents, both the petitioner has not cooperated with the investigation. Only the petitioner are appeared before me and assured to submit all the relevant documents, but after receive the said letter, both are intentionally avoid and not submitted single relevant paper.
That you have written, but a type of chithi in reply आपन को दिया ही थिला कि नहीं, जो चिट्ठी रे लेखा हिची जे डॉक्यूमेंट गुडा को जहा लेखा हिची मुसे
that is not available now.
से एफिडेविट आपन ऊपर कॉपी नहीं, कारण आपन को इंस्ट्रक्शन नबार अछि ना ये एफिडेविट ऊपर व्हाट ही हैज मेंशनड जोटा तादर लेखा हिची, लेट अस से that ICICI Bank account freezed by the banker as per the direction, whether it is a correct or not.
That document which is required by the IAC, IO, is not seized by the
से परा कहउछंती सेइत पय मु कहउची आपण एफिडेविट ता पढिथिले जानिथान से कोन तारो जो आईआईसी रो चिट्ठी रो जवाब रे से कोन लिखिछंती, that has been quoted there, से लेटर रो तांकर रिप्लाई रो एक्सट्रैक्ट सेठी कोट हेछि, तेणु से एफिडेविट ता तो नाही आपण पर मु तां कहउची आ गोटा एफिडेविट आपण को दियंतु, but whether it is available or not with you.
Yeah, I'm just verifying.
4th August 2023.
ମୁଁ ଗୋଟେ memo ଦେଇଛି.
Yes, my lord. That is available.
Now on 4th, you see that document.
Yes,
See,
yes.
come to paragraph 3.
3.
It is his letter dated so and so. Again, another letter that is 7/5/2022. What he has written, it is mentioned. And then the okay, Mr. Patnaik, you have mentioned in paragraph number 6 of
Yes,
that
ma'am.
particular affidavit, which he is also wanting, that IO is wanting that the petitioners, petitioners have obtained the documents from Register of Companies website by depositing fees. Steps have already been taken by the petitioner before the Register of Companies for certified copy of the document pertaining to the appointment of the petitioner number 2, and the certified copies are awaited. So this
Yes, my lord.
the IO
I
wants.
have given the copies of the website, my lord, available. That is Annexure 8 series, my lord.
It's all right, but they why don't you? This affidavit was filed in August and we are in February, so there should not have been such kind of delay for obtaining the certified copy of this document. If it is available in website.
Is having there, my lord.
My lord, my associate is having the certified copies of the Register of Companies, my lord.
That's all right, but it has to be given to that IO. He is wanting that.
We have already
IO is wanting the original document. Original document, court resolution.
Original document, it is must have been there. So the certificate.
It is with him, my lord.
He's not selling it. So what is the difference? What that document?
That signature of the other directors was forced. That is the main contention. That
certified copy रे जो signature थिबो सेटा तो सही signature थिबो ना आउडे कोन signature दे दी थिबे
नहीं नहीं जोटा देइछंती कंपनी ऑफ रजिस्टर सेटा जेरॉक्स कॉपी देइछंती ओरिजिनल देइ ना
Original
is with them.
Associate will be handing over the original because the ROC, whatever the material available with ROC has provided, my lord, and others are under lock and key, my lord.
That petition number 2 is a director. That is evident from those documents. The Register of Companies has accepted it.
And what about your instruction? You have not taken any instruction on this particular affidavit. The second one that this has been paid to different creditors. The company ro jo se jo 26 lakh टंका total receive ହେଇଛି 50 lakhs and all 24.
That is we have no instruction regarding that. No knowledge also. He has not given any paper.
May I submit something, my lord?
Wait. Your case as for the FIR that 50 lakhs he has received in another account, right? He's making a submission that out of that 50 lakhs,
26
lakhs has been given to the different creditors, as might have been supplied goods or whatever it may be. And what is that amount? And who are those parties that names has been furnished in that list, right? Number 2, the rest of the amount is available in that account itself. That means 24 lakh. So if that be the correct state of affairs, company ro टंका यांको account भी जदी जाइनी ताले misappropriation केमती से कले?
That account is a fake account, मिलो.
सी गोटे account टा खोली चंदी ICICI बैंक रे खोली चंदी. ICICI बैंक को जो टंका टा आसिला सेटा जदी कोनोसी illegal way रे utilize हेइनी, right? And they are producing it's a document which has been obtained from the register of companies, right? And that shows that this petition number 2 is the. So how do you disbelieve everything? If this is not taken into consideration, this is the certified copy with having the seals, etc.
Let them supply.
My lord, we have already
Sir, may I submit, my lord? These persons who in whose favor the amounts were disbursed, as per page 23, they are not the creditors. They have no link with our company, your lordship.
We do not know. That's when you receive the bail order copy,
My
the
lord.
stand has been taken that this is the amount which has been given to the creditors.
Yes,
Is it not your duty to file an affidavit saying that these persons are not?
I'll file
I
the
will
affidavit
file
by the
one
next
account.
date, my lord.
Submission has been made, averments have been taken, documents have been annexed that the
Sir,
amount
I'll
has
file an
gone to
affidavit,
the
my lord.
creditors, and you will just say orally that they are not the creditors and we'll accept it.
I'll file the affidavit, my lord. I'll file the affidavit to that effect with relevant documents, your lordship.
Man, online payment has been banks, man.
Bank receipt.
There is
All are
documentary
bank
evidence to that effect. Online payment has been made, and you will say that they are not no way related to the so. Unless the amount has been misappropriated, the question of where is the question of this
The creation of the bank account is itself fraudulently done by forging our signatures, your lordship. That is the
bank account forged ହେଲା, that's a forged ଆପଣ misappropriation ର ଯୋଉ charge ଟା ଆଣୁଛନ୍ତି, misappropriation କେମିତି ଆସିବ
My lord, I will file an
ଟଙ୍କାଟାକୁ
affidavit.
ଯଦି ତାଙ୍କର ନିଜ ପାଇଁ ଖର୍ଚ୍ଚ କରିବେ ଅଲଗା କଥା, ଯଦି ଟଙ୍କାଟା କମ୍ପାନୀ ନାଁରେ ସେ ଆକାଉଣ୍ଟ ଖୋଲା ହେଇଛି, ଯଦି ସେ ଟଙ୍କାଟାକୁ କମ୍ପାନୀର ଯୋଉମାନେ କ୍ରେଡିଟର ତାଙ୍କୁ ଯଦି ଡିସବର୍ସ କରାଗଲା, ଇଏ ମିସଆପ୍ରୋପ୍ରିଏସନ କଣ କଲେ?
My lord, I will file an affidavit to that effect, my lord. In the affidavit of August that may be solved on us, my lord. That is not with me. If your lordship directs.
Learned Counsel for the state submitted that on the affidavit filed on behalf of the petitioners dated 4/8/2023, it may be given some time to obtain instruction. The Learned Counsel for the petitioner also produced the certified copy of some documents issued by Deputy Register of Companies cum Deputy Official Liquidator Odisha Cutter to show that.
My lord, page 13, your lordship. The names of the directors.
Page 13.
Yes, my lord, of the affidavit.
Mentioned that one Abhishek Mahapatra.
Yes, my lord, that is with their allegation that Abhishek Mahapatra has been taken as a director.
Now, this is the document relates to that Abhishek Mahapatra.
Mahapatra, my lord. These are all the documents relating to Abhishek.
Abhishek Mahapatra is petition number 2.
Yes, petition number 2, my lord.
And son of petition number 1.
The petitioner number 2 had given his consent to act as the director of Brahmani Indican Private Limited. Let the copy of these documents be supplied to the Learned Counsel for the state. So also
no, in the affidavit you have supplied.
Yes.
Xerox copies.
No, he wants this just these documents which are there. You just supply this Xerox copy of the certified copy which you have obtained.
All right, madam.
And let a copy of the affidavit dated so and so be supplied to the Learned Counsel for the informant who seeks some time to obtain instruction as to whether the averments taken in the bail application, so also the document which is filed at page number 23 that rupees 26 lakhs and odd has been given to different creditors of the company. So जो ब्राह्मणी engineering गोटे जगह लिखे तापरे hereafter the company is correct or not. So free copy of the order be handed over to the land council for the state. So Mr. Patnaik just hand over a copy of that affidavit to the land and council for the informant. Affidavit dated. This document you are filing for today.
Yes,
the land and council for investigation petitioner. State files the submission of the detailed investigation report.
Last occasion they had submitted.
Which is taken on record for them. यारो किए एटा सबमिट कले आपण आर जेरोक्स करिकिन तांगु देई देबे अछि ओइटा को नियंतु रेकॉर्ड these are taken on record कले bring it in the week commencing from 26th of February.
Mala 26th they had some other case now.
No, 26th February it will come on the Friday. That means it will come on March 1st.
March 1st, maybe.
Yes.
Supplementary करना ही पड़ेगा.
Obviously, it will come in the supplemental list. Yes.
Great.
Item 3.
Obligations. May I please your lordship? On the basis of the FR lost by the one Rohiteshwar Naik and others, the present one initially one FR was registered against one Sanjeev Kumar Pradhan advocate.
Please use the mic properly.
On the basis of the FR lost by one Rohiteshwar Naik and others, the petitioner along with 3 others have been implicated in an offence under 419, 420, 467, 468, 34 of the Indian Penal Code. The prosecution case is like this, my lord.
No, I asked the London State Council to obtain instruction since it's a case of the year 2017, whether processes under 80 to 83 CRPC has been issued or not. And what is your instruction?
That has not come.
2023 ମସିହାରୁ ଗୋଟେ ଅର୍ଡର ଫାଇଲ ହେଲାଣି ଆପଣଙ୍କୁ ଅର୍ଡର ହେଲାଣି
18/1 ରେ ଚିଠି ଯାଇଛି.
So what do you want?
Next week
he's availing the interim protection order, so he has no difficulty in that sense. All right, the London Council for the State seeks some time to obtain instruction as per the order dated 12/1/2024. Put up this matter on 23rd of February 2024. Interim order dated 5/1/2024 is extended till next date.
Obligor.
Item 4.
May I protest? Last time we called for the CD and CA.
Earlier anticipatory bail application was
Yes, my lord.
disposed of and you were asked to surrender and move for bail. So why have you again come?
Annex 2 page 12, my lord. ସେଥିପାଇଁ ମଗେଇଥିଲି ଆପଣ. Similar putting ରେ ମୁଁ ଅଛି ସେମାନେ ବେଲ୍ ହେଇଛନ୍ତି.
Mr. Tripathi,
Yes, ma'am.
after the first anticipatory bail application, in which the direction was passed to surrender in the court below and move for bail, another co-accused has been granted bail by this court. So he is claiming parity. So you are supposed to verify the case record, whether this person, this accused, and the person who has been granted anticipatory bail subsequently, they stand on the same footing or not. So that order was passed on 12/1/24.
Sarman Shah.
सरमन शाह जी बेल
Guldit Singh.
गला ता ना होची
Guldit
गोल्डी
Singh
सिंह
alias
alias
Harjit Singh.
हरजीत सिंह
Yeah,
and
this person have no antecedent.
कहार
Sarman Shah.
नहीं सरमन सर बाकी जो एंटीसीडेंट तो नहीं
Yeah.
बट जहाँ नेचर ऑफ एक्यूजेशन अच्छी सेटा से जो दी जण एक्यूज जो जाइछंती से जो तादेर केते जण एक्यूज जाइतले बेले
दी जण अछंती
गोल्डी सिंह जनक ना
Yes.
आउ जनक ना कोन वरी दैट ऑर्डर माने कंप्लीट ना आसुनी ना देरे ऑर्डर रे so you are just to verify that as for the accusation.
Next row no. Yes, madam. ढापारे खाइବାକୁ ନେଇ ଗଣ୍ଡଗୋଳ ହେଇତାର
See,
Share
you
ଥିଲା
see that in the FIR also it is mentioned
ହଁ
abusing and then Sarban, Aryan and Goldie
Goldie
started assaulting my son with so and so, and due to the assault or by so and so he sustained injury. So ଦି ଜଣଙ୍କ ନାଁରେ similar allegation ଆସୁଛି ତା ଦେହରୁ ସେ ଗୋଲ୍ଡି ଯିଏ ସେ ରିଲିଜ ହେଇଗଲାଣି ବେଲ ସେ ସେଇଆ ହିଁ sufficient.
same
Or the learned counsel for the petitioner, learned counsel for the state. As per order dated 12/1/2024, the learned counsel for the state was asked to verify whether the petitioner whose anticipatory bail application in ABLA PL number 2444 of 2021 was rejected is similarly situated like the co-accused persons who have been subsequently released on anticipatory bail in ABLA PL number 2829 of 2021, released on bail khali kar diyanti in ABLA PL number. Learned counsel for the state has produced the case diary and on verification fairly submits that the petitioner is similarly situated like the co-accused Goldie Singh alias Harjit Singh
and another
who has been granted bail in ABLA PL number 2829 of 2021. In view of such submission made by the learned counsel for the respective parties and the nature of accusation, release of the co-accused on bail, I am inclined to release the petitioner on bail, and accordingly it is ordered. Yes, next.
obligatory.
Item 5.
Last time I was granted to the to get the copy of the deposition and also the instruction regarding the death of
You have received the copy then. ଯୋଉମାନେ ହେଇଛନ୍ତି ମିଷ୍ଟର ତ୍ରିପାଠୀ, ଯୋଉ 10ଟା ସାକ୍ଷୀ ନା 12ଟା ସାକ୍ଷୀ ହେଇଛନ୍ତି, ସେମାନେ ୟା ବିରୁଦ୍ଧରେ କଣ କହିଛନ୍ତି? And this man is in custody since when?
15/12/2020
Your earlier bail application was rejected in
BLAPL number 1124 of 2021.
Heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 15/12/2020. And when he approached this court for bail in BLAPL number 1124 of 2021, as per order dated 24/8/2021, the bail application was rejected. Learned counsel submits that in the meantime, trial has commenced and 12 witnesses have been examined and nothing has come against the petitioner. On 8/12/2023, when the matter was taken off, learned counsel for the state made a submission that one eyewitness, Kobita Polei, who is also an injured, is yet to be examined. And as such, this court directed the IAC to appear before the London trial court, receive summons in respect of the said witness Kobita Polei and ensure her attendance on the date fixed. Today, however, the London Council for the State has produced written instruction received from the IIC Baluga police station that Kobita Polei has expired since 2012. In view of the written report furnished and the nature of evidence adduced so far in the trial court, and further taking into account the period of detention of the petitioner in judicial custody and change in the circumstances after rejection of the earlier bail application, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail allowed.
Item 6.
May I please? My lord, custody since 7/12/2021. Offense in under section 20B2C of NDPS. As per the prosecution report, while the police are performing patrolling duty, they
How many witnesses have been examined?
my instruction, 3 witnesses already been examined, and last witness has been examined on 27/2/2023. Last witness on 27/2/2023.
This is the report dated 10/8/23 has come, wherein it is mentioned that out of 18 charge sheet witnesses, 5 witnesses have been examined. And the case was posted to 16/8/23. So what instruction you have received, that is much of February 23. We have the information of August 23. What happened thereafter, I just want, not that 2 witnesses examined. 5টা witness পরে ଆଉ କେତେଟା ସାକ୍ଷୀ ହେଇଛନ୍ତି? ଆଉ କଣ ହବ? Now you are apprehended at the spot.
2 persons are apprehended on spot. One is absconding after getting interim bail.
So let a fresh status report come, we'll take up this one. Status report dated 10/8/2023 submitted by the trial court, London trial court, indicates about examination of 5 witnesses out of 18 charge sheet witnesses. And the said report further indicates that the next date of trial was posted to 16/8/23. Since the London counsel for the appellant has no instruction as to what happened on 16/8/23 or thereafter, let a fresh status report be called for. Put up this matter, give a date. Yes.
Deposition. Deposition.
And if any further you have got the deposition of these 5 witnesses.
No, my lord, till
All right, deposition copies of the witnesses examined be sent to this court along with the status report. Yes.
Item 7.
Please, my lord. The last date of hearing, my lord, it was instructed and the time has taken by the special public prosecutor for the examination to verify their criminal antecedent and the petitioner whether the address furnished by the petitioner in the cause title of the bail application is correct or not. So at bar, my lord, I am stating that the address is true and maybe the address is verified by the agencies, my lord. And it is very unfortunate. The under trial prisoner, the FIR is lodged in 2009, my lord, and the person who is arrested in 2019.
Mr. Naik.
Yes, Your Lordship.
Now, 2 things you are required to do. One is
3 things, in fact, Your Lordship had told me on the last date of hearing. One is to find out the criminal antecedents.
Right.
One is to verify the address.
Right,
and the third thing, Your Lordships, I don't know whether it is reflected in the order or not. Out of all the witnesses examined, how many people have told about him?
Right. These are the 3.
That question also Your Lordship had asked me. If Your Lordships will remember, sir was not there during the previous dates of hearing. Your Lordships had asked, I think, Mr. Amulya Ratna to provide a list of the witnesses, those who have specifically said that Bablu did it. If Your Lordships will remember. Out of the 16 witnesses, Your Lordships, of the list, I verified 3 people were dead, Your Lordships. One statement I could not get it, Your Lordships, but out of the rest 12, all the 12 witnesses have implicated him, Your Lordships. So, Your Lordships, when I am typing Control F and typing Bablu, out of the witnesses of 12 witnesses, those who have been examined, 113 times the name Bablu is coming, Your Lordships. I am filing it, Your Lordships. All the witnesses who have been examined till now, 12 witnesses have directly implicated him. Sir might have read those statements also. Number 2, Your Lordship, sir is saying that it is unfortunate he has been in judicial custody, Your Lordships, because 10 years he was absconding.
That I have noted down.
It was unfortunate that he should have joined the trial from the beginning. Nije absconding, how it is unfortunate. Now, further, Your Lordships, we have verified the address. The address, Your Lordships, which is available, it is his native village, but none of his family members is found there till date, Your Lordships. His father has expired. Neither his wife nor the brother is residing there at present. The premises were found to be locked, Your Lordships. Sir, am I correct?
My lord, wife and 2 kids are there. They are residing in the matrimonial home.
No, one thing.
Yeah.
That the submission which you made, that the witnesses examined so far have not stated anything against you. That is said that he has verified and found that witnesses have in fact implicated you.
At the time of the granting of the bail under 439, my lord. So that is not material part at this stage to grant the bail upon the basis.
According to you, the material thing?
Please,
You are
madam.
an absconder for 10 years.
No, I am not absconding. I am not absconding. The FIR is registered in 2009.
Yes.
And the charge sheet has been filed in 2010.
Yes.
Then the one of the accused, who is the primary accused, he has stated my name. Then the further investigation has been conducted by the prosecution, and then I have been arrested in 2019. I have not known. Even the FIR is not in my name, your lordship. Please see the page number.
When you are charge sheeted?
I have been charge sheeted in 2011, my lord.
So, when you are charge sheeted under section in 2011,
please,
and you are shown as an absconder,
yes.
How do you say that you are not aware, or you are when you are apprehended? You yourself said that you are apprehended in 2019.
I have been arrested in 2019.
Right.
Right.
So 2011, if charge sheet submitted, you are shown as an absconder. That's a correct statement or not? You just said that.
The charge sheet is filed, a supplementary charge sheet filed.
I do not know. You said I made a statement. I asked for you that when the charge sheet was filed, you said it is 2011. Next query was that whether in the charge sheet against you it was filed or not.
My
you said
name,
yes.
My
So
name.
if 2011 charge sheet has been filed and you were shown as an absconder, you were arrested in 2019, then they are right that the case is of the year 2009, and with much difficulty you are taken into
At
custody.
this stage, my lord, I am filing I am relying upon the one judgment, my lord. If the prosecution is taking the plea regarding the absconding, the purpose of the bail under 439 is only to secure the presence, firstly, and secondly, not tampering the witnesses. My lord, please.
What is the citation?
Absconding for so many years, then what is the guarantee that if you are granted bail, you will not abscond?
This court may impose whatever the condition. I shall avoid for that, my lord. So,
the question of imposing condition arises only when the court is satisfied that there would be no chance of absconding, but it is the absconding material is already available on record.
My lord,
you are an absconder for so many years.
Absconding or not. So, annexure 3 of this charge sheet, column number 16, page 84 of this instant bail petition, Your Honor.
What they have done, Mr. Naik?
Yes, Your Lordship. Your Lordship, may read the rejection order, Your Lordships. I'm taking it out. Your Lordships had dealt with this bail application thoroughly, Your Lordship. The first bail rejection order, Your Lordships. I think 2747, Your Lordships. If Your Lordships has the first bail rejection order, I'm just taking it out, Your Lordships. I'll read it.
Oh, appointment letters were issued by these fake appointment letters issued by railways to persons, and that they have been appointed in the railways, and 95 lakhs have been collected. That is the charge sheet submitted. That is appears from the.
I'm not involving in this matter, my lord, and I am.
If your lordships will come to sir, 1 minute. Sir.
This is not where you are guilty.
Sir, your bail application number is 2747 of 2019, your lordships. If your lordships had the rejection order, the first paragraph I would like to read, your lordships. Your lordship starts this judgment with, unemployment is a social misery. For an unemployed person, every day becomes a day of hardships, curse, restlessness, and uncertainty. One who cheats such a person in such a situation, giving false assurance of providing job, takes away his hardships, hard acquired money, is perhaps the worst creature on this earth, and he does not deserve a place in this beautiful world created by God. Totally deserve and there is no change in circumstances, your lordships.
That is why I am submitting before this honorable court at this stage, granting of this bail that not be considered what is the government and the submission
Your
of
lordships has already, your
prosecutor at
lordships
this
have
stage.
already rejected
Because
the bail on
I am
merits.
seeking the bail. I am seeking the bail under 439. My lord, at this stage, I relied upon the judgment of the Sanjay Chandra versus CBI passed by the Honorable Supreme Court. Whether detention of under trial, please, my lord. The
All
copy.
right. I have a hardy order reserved. Yes.
The copy, my lord, please.
Give it. Yes. Next.
Please, my lord.
Item 8.
Taken up, my lord, at least 2 chapter, my lord.
Okay. Land counsel for the petitioner at his.
Item 9.
Yes. Yes. May I please the lordship, my lord? Present petitioner, my lord, has been behind bar, my lords, since 25/11/2020, my lord. Yes. Yes, may I please, lordship? Present petition is behind bar, my lord, since 25/11/2020, being charged under section 420, 406, 409, 467, 468, 471, 379, and 120B and 34 IPC. And charge sheet column shows, my lord, there are altogether 21 witnesses have been figured in the charge sheet, my lord. Out of 21 witnesses, my lord, in the meantime, 6 witnesses have already been examined. And on identical allegations, my lords, it appears from that report filed by the Learned State Council. Crux of the case is that present petitioner was working as a gold appraiser since 2011 in the IFL company. 3 to 4 years prior to the occurrence, the accused Lala Amritasagar Rai hatched a criminal conspiracy with his colleague Nilima Lenka and Kavi Prasad Pradhan, Satyam Pradhan, and others, and they started misappropriating the mortgage gold and cash of customer IFL, my lord. In the meantime, my lords, on identical allegations, my lord, lordship would find Satyam Pradhan, my lord, who was the branch manager, my lord. And he has already been admitted to bail, my lord, along with the other 2 co-accused persons. So my sole submission before my lord is that the release of the co-accused persons on bail, coupled with the fact that there is a slow progress of trial, and present
Satyam Pradhan has been granted bail by the Honorable Supreme
Court, my lord. And other 2 co-accused, one of the Sarojit Twisty released on bail by this Honorable Court, and co-accused Lalit Soni has also been admitted to bail.
Yes, these are the bail orders in this particular case.
Yes, my lord.
There is Satyam Pradhan 1, then Aude case. Saroj Kumar Pushti.
Yes, my lord. By this court, my lord.
No, this is by Justice S.K.MISHRA.
Yes, my lord. By this court, my lord.
Then
our another Lalit Soni.
Lalit Soni again by the Honorable Supreme
Court, my lord. Subject to verification by the Learned State Council, my instruction goes to show that, my lord, another co-accused, namely Prakash Sahu, has already been admitted to bail on by BLA bill number 9681 of 2021.
in the earlier, when I rejected it,
He was in present.
In the specific paragraph, I have stated that what is the role attributed
Yes,
against
my lord. Present
this
petitioner
man.
was not a petitioner by that time.
Okay.
Yes, he was not a party to that order.
So, what is the role attributed against him? As
That
per
I have already filed.
They have already filed.
I have already filed.
They have filed a synopsis, my lord.
who did you?
Ayuk.
Your
Evidence.
lordship has directed me to file.
Just a minute. ସେଟା ଦିଅ ସେଟା ୟା ନାଁରେ କଣ allegation ଅଛି? ये जो 13/12/2023 ର letter ଟା କି? ନା ନାଇଁ?
13/12/2023 में.
Yes, my lord. That is.
Okay. Lala Amritra was an employee of IIFL Naya Sadak branch, working as gold appraiser since 2011. 3 to 4 years prior to the occurrence, accused hatched criminal conspiracy with his colleagues. Swanso Satyam Pradhan is there, and they started misappropriating Swanso gold and cash of the customers of IIFL. To succeed his ulterior motive, Lala and his associates started doing forgery of the documents, theft of so and so from the vault of the company, cheated the customers as well as the company in several ways. The method adopted by accused Amrit Sagar Roy is that he used to close the gold loan of the customers by receiving closure amount and handing over their placed gold ornaments, but actually did not close the gold loan in the company system, thereby misappropriating the money given by the customer towards closure of the so. He tampered with the golden packets, took away the placed gold from the packets and used the same for obtaining new loans in favor of some other customers by creating fake loan accounts to misappropriate funds. How do you say you are similarly situated? You are the main person seems to be that.
Because there is no positive evidence that, my lord, this man was entrusted with that work, my lord.
That is to be proved. The trial is going on. That is to be proved.
6 witnesses have already been examined who have also not supported that story advanced by the prosecutions. And in that petition, my lord, Satyam Pradhan was the branch manager, my lord. Entire system manned by him, my lord.
No, branch manager, it's all right, but you are the main person as it appears here.
This man is gold appraiser, my lord.
You were tampered with the gold loan packets, took away the placed gold, and then obtained new loan in favor of so and so. All these things are against you.
Not a single witness has also stated that aspect while giving their statement before the I under section 161 service, my lord. And his status is gold appraiser, my lord. Only to evaluate that gold and to purify and to examine the purity of the gold in question, my lord.
A gold appraiser maintaining 3-story building and having a Audi car.
That Audi car in Audi car.
Want to breach the security of the vault, accompanying to so and so opening
Audi
vault manual.
Audi car.
No, that is mentioned also here. In detail mentioned it is. When the misappropriation become huge, then you could not able to manage the audit, then you planned it out, and then this Dokai thing came and everything was done. But it started since 2011. Slowly you just
they removed the gold from the pouch and replaced them.
There was an internal audit, my lord, within 15 days, my lord. They have also admitted there was an internal audit, my lord, within 15 days of that company question, my lord.
and the Land Council for the petitioner, Land Council for the state, Land Council for the bank, no?
Yes.
The Land Council for the petitioner submitted that the petitioner was taken into judicial custody on what date?
25/11/2020.
25/11/2020. And he is now availing the interim bail as per the order of the Honorable Supreme Court. Dated 11/10/2023, which was extended from time to time. The Land Council submits that some of the co-accused persons, namely Satyam Pradhan and Lalit Kumar Soni, have been released on bail by the Honorable Supreme Court. And co-accused Saroj Kumar Pushti has been granted bail by this court. And he has filed the copies of the bail orders with a memo which are taken on record. Submitted that the accusation is almost identical in nature. And in the trial court, out of 21 charge sheet witnesses, only 6 witnesses have been examined. What are the offenses here?
Offenses are tribal learned magistrates 420, 406, 409, 467, 468, 471, 379, 120, 34 IPs.
And the offenses are triable by magistrate, and therefore the bail application may be favorably considered. Learned Counsel for the state has produced what all of it? देखुଥିଲି କଣ? ହଁ. Where is that you filed it, Mr.
Yes,
Just a minute.
That letter 13/12/2020.
What all the letter ta kod ala? It 13 no it.
Yeah, sure.
Produce a written instruction received from ACP Zone 3 Cuttack UPD regarding the role played by the petitioner and the evidence available against him. Considering the submission made by the Learned Counsel for the respective parties, the nature of accusation against the petitioner, the period of detention of the petitioner in judicial custody, the progress of the trial so far, and the release of the co-accused persons on bail. And since the offences are triable by magistrate, I am inclined to release the petitioner on bail subject to condition that he shall appear before the London trial court on each date when the case would be posted for trial, and shall not try to tamper with the evidence, and shall not indulge in any criminal activities, violation of any terms and conditions, shall entail cancellation of bail. Yes. এটা লেখিলে তো जो फाइल कले बेली जो BLA field ये रे 3133 এটা ने. Yes, what are these connected to matters?
Other co-accused.
Okay, ସେଠି ୟା ଦେହରେ ଆପଣ ଦେଇଛନ୍ତି ତାଙ୍କର
ସବୁ ଦେଇ ସବୁ
ଆଚ୍ଛା ଏ ସେଥିରେ ମଧ୍ୟ ସେୟା ଲେଖିବେ in addition to ଆଚ୍ଛା date of custody କୁହନ୍ତୁ.
So far as this Nilima Lenka is concerned,
Lordship, he was arrested on the same date, that is 25/11/2020.
लिखिले तो same day. And Debasis Hajra 30/11/2020. Okay. So ये ସେଇଟା ରହିବନି ଆ ଧିରେ ସେ ଯୋଉ he was granted interim bail କାରଣ interim bail କେବଳ ଆଙ୍କୁ ଦିଆ ହେଇଥିଲା ଲାଲା ଅମୃତ ସଗର ସେଇ ଲାଇନ ଟା କଟିବ ବାକି ସବୁ ରହିବ. Yes.
My case also Santosh Bhai 25/11.
That's another case, item number 10.
Item 10.
Yes.
Item 10. So item 10.
Yes. Yes.
Sorry, yes, sir.
Item 10.
Yes,
Yes, I have already given that.
In the present case, my lord. Yes. Charge sheet has been filed, my lord. 395, 411, 412, 409, 120B, 201, 420, 34 IPC, along with section 25 and 27 Arms Act, my lord. Charge sheet shows, my lord, there are altogether 142 witnesses have been figured in the body of the charge sheet, my lord. Till today, my lords, only eight witnesses have been examined who have not specifically implicated the present petitioner as any of the as one of the author of the crime. Subject to verification by the London State Council, with great respect, I submit, my lord. Most of the witnesses have been examined till today have not supported the prosecution case, my lord. That apart, my lord, in the meantime, my lord, some of the co-accused person, one is Prakash Kumar Sahu, my lord, another is Satyam Pradhan, the branch manager, third is Lalit Kumar Soni, my lord, fourth is Saroj Kumar Pushti, my lord, and except that Lalit Kumar Soni, my lord, other co-accused persons, including that Satyam Pradhan, who is the branch manager by the time of alleged incident had taken place, have already been released on regular bail by this honorable court, my lord. I have already supplied that copy to you. Copy of deposition and এটা হচ্ছে লালবাগ পিএস কেস নম্বর 294 of 2020. Yes, ma'am.
Yes, Miller. 294.
So এটা হলো প্রকাশ কুমার সাহুর বেল অর্ডার. Yes, ma'am. Then it comes Satyam Pradhan. Yes, ma'am. Lalit Kumar Soni by the Honorable Supreme Court. Yes, ma'am. Then Saroj Kumar Pushti. Yes, ma'am. Saroj Kumar Pushti. ଆଧିରେ ଆପଣ କେବେ ଦେଲେ ଯୋଉ ଅବଜେକ୍ସନ ଯୋଉଟା ଦେଇଛନ୍ତି
Same day.
ଆଧିରେ ଦେଖିଲ
Totally different. 11/12/23. Same day.
এই কেসটার ଦେଇଛନ୍ତି ନା ଆଉ କୋଉ କେସ୍
6511.
6511.
Yes.
হ্যাঁ
এটা যেটা ଦେଇଛନ୍ତି କି 11, 12, 23 ର
11, 12, 23
Yes, Mr.
Yes, my lord. That objection shows, my lord, statement, my lord, permission placing statement of employees Basant Behera security guard, Meena Behera housekeeper, and others implicating her for depositing gold in other branches of Manapuram, my lords. In the meantime, my lord, the said Basant Behera is examined as PW8, my lord, and said Meena Behera examined as PW3, my lord. None have supported the prosecution case in any manner, my lord. So, my lord, the release of
Which paragraph you placed from that report?
that objection filed by London State Council.
Yes, yes.
Paragraph number 3 towards column Roman 2, my lord.
Paragraph number 3.
Roman 2, my lord.
Yes.
Statement of employees Basant Behera, security guard, Meena Behera, housekeeper, and others implicating her for depositing gold in other branches of Manapuram. The said principal witnesses, my lord, examined as PW3 and PW8 respectively, my lord. I have supplied that photocopies of the deposition, my lord. None has supported the prosecution case in any manner. Meena Behera.
The Honorable Supreme Court released that Lalit Kumar Soni
on bail, my lord.
What was his role?
Role virtually, my lord.
Totally different.
He was a party to that conspiracy, my lord. He was a party to the conspiracy, my lord. It is not.
You are claiming parity.
Yes, my lord.
That case in which I have granted bail, that's a different. It's a magistrate tribal offense.
Yes,
but this is a sessions tribal
yes,
offense. 395 case and the bank robbery is there. So in the broad daylight, all these things have been committed and in the heart of the Cuttack town and the gold ornaments were taken away. You are identified in the in the test identification parody you are identified.
No, my lord. It's
recovery of the gold ornament.
It is alleged that present petition assisted others to carry out the reveal design.
Because of that, he could not manage that.
It is alleged. Present petition along with that manager, the then manager, my lord.
So these persons, they do not stand in the similar footing.
Because 2.5 years inside custody, my lord.
One is it's all right. One is that
Satyam Pradhan, the then manager, has already been released on bail.
Manager role and
she has managed everything, my lord. According even that witnesses have also stated. Eight witnesses have already been examined. None has supported the prosecution case, my lord. Charge sheet shows that there are 142 witnesses, my lord. There is extremely slow progress of trial, my lord. Prior to that, my lord, present petition has got no criminal antecedent, my lord. He was also released on interim bail and which has been extended by my lord on time and again. During the enjoyment of that interim liberty, his conduct was very orderly and excellent. He never misused the liberty granted to him in any manner, my lord. While extending that interim bail, the apex court has also taken care that plight of that ailing condition of his child and other familiar difficulties is there also. That observation is there, my lords.
Are the learned counsel for the petitioner, learned counsel for the state?
Lordship, I mean, batch of bail application lordship passed an order, little order. If you to see page 34, particular dealt the role of the petitioner. Lordship page 34. In application that BLFL 8211, 822 by 221.
The Lordship, a common order was there.
No,
It's
present
34 just I'm not reading. What is the goal, my lord?
present Bishop was not a party to, was not a petitioner before earlier, my lord.
Well, it was not defined. But see, I'm just reading out. So the course of investigation, it is revealed that
A2, what is that?
My lord,
What is the number which you are telling? Which
Lordship, page 34, Lordship, one accusation against the petitioner Santosh Bhai alias Bhapi. And that kind of bail application, Lordship has described the role of the current petitioner.
No, he says that in that application, the petitioner was
not
not
a party.
a party in that. This is the first bail application of the petitioner.
Lordship, there his role was also
That observation.
So the course of investigation does reveal that being directed by the petitioner Ranjan Kumar Behera as per the instruction of accused Lala Amursagar Rai.
When the charge was framed in this case?
On 9/2/2023, my lord.
Are the learned counsel for the petitioner, learned counsel for the state, learned counsel for the informant? The learned counsel for the petitioner submitted that the petitioner is in judicial custody since
25/11/2020.
25/11/2020.
20 my lord. 25/11/2020.
And was taken into judicial custody. And out of 142 charge sheet witnesses, only 8 witnesses have been examined, even though the charge was framed on 9/2/2020. He further submits that co-accused persons Prakash Kumar Sahu, Satyam Pradhan, Saroj Kumar Pusti have been granted bail by this court, whereas Lalit Kumar Soni has been granted by the Honorable Supreme Court. He files the copy of the bail orders with a memo which is taken on record. He further submits that 8 witnesses examined so far have not stated anything against the petitioner. And in view of the slow progress of the trial, the release of the co-accused persons, the bail application may be favorably considered. Learned counsel for the state as well as learned counsel for the informant oppose the prayer for bail and submits that if the petitioner is enlarged on bail, there is chance of tampering with the evidence. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody, the release of the co-accused persons on bail by this court, so also by the Honorable Supreme Court, and the slow progress of the trial, I am inclined to release the petitioner on bail allowed. This is item number 10. Item number 10 এটা হচ্ছে BLPL number 6511 of 2022. Right? Yes. Santosh Bhai, BLAPL number 3430 of 23.
My lord.
Yes.
My lord, similar.
What is the role played by this man?
He committed dacoity.
For dacoit, then you remember. You are identified in the TA period.
CCTV footage.
Okay.
Only 40 grams of.
No, you are they are the bank employee. You are the person who committed dacoit in view of the available material on record. And since it's a case of dacoity in which the petitioner's role is forthcoming from the CC camera and other materials, and also the recovery of the gold, I am not inclined to release the petitioner on bail Rejected. The London trial court is directed to expedite the trial. Yes.
Bail application number 3188.
Then the 3188 of 23, Nilima Lenka.
Employee.
Huh?
She was an employee.
Employee of this was also say, what is the date of custody?
Lordship, 3 years and 3 months. She was arrested on 2011-2020.
2011-2020. So you write out similarly situated coaches. से जो ना गुड़ा का दे कॉपी करी पेस्ट कर देगा है ना एंड लेडी कर देगी बेल अलाउ कर देगा yes BLAPL 4486 of 23.
Yes, my lord. Petitioner remanded to this case, my lord, on 9/7/2021. And offense, my lord, tribunal magistrate.
Hmm. No, why it has been tagged with this case?
Other tag agency.
Huh?
Also the tag agency, what the offense, my lord, 420, 406, 409, 467, 468.
There are two cases connected.
There are three Lalbagh PS case number 321.
ଯୋଉଟା ପ୍ରଥମଟା ନା
ଏଇଥିରେ କେମିତି ପଶି ଯାଇଛି
ରହିବ 9 item
ଅର୍ଡର ହେଇଥିଲା ଯେ यार कनेक्टेड मैटर डिस्पोज ऑफ हेलानी केते नंबर आइटम नंबर 9 एटा 9 रो तो 9 ने जो ऑर्डर हिची नैतिले तांकु दे दे एंड व्हाट इज द डेट ऑफ कस्टडी
remanded to this case on 9/7/2021.
तो लेखि देबे दे एटा होची BLAPL number 4486 of 23. The London Council for the petitioner submitted that the petitioner was taken on remand in this case on
9/7/2021.
21. And बाकी सब जिनस गुड़ा के सेथुर नहीं आसीबे co-accused released on bail तापरे magistrate tribal offense सेउडा नहीं आसी bail allowed 9351 of 23. Yes. Who is this person, Mr. Devasis Hajranar कौन allegation है? से डकैत allegation ना से बैंक रे employee?
डकैती केस
395 is not there against me. I have only been implicated for aiding and being engaged by the Lala Missouri. I'm not an employee of the bank.
See what is there, Mr.
Let it come next week, Muller. Let us have no instruction.
Instruction, that is.
Okay,
No.
next week, as prayed for by the London Council. Verify whether he is the docket or that.
Yes.
Okay, next week. Yes. Item 11.
Item 11.
Present petitioner, my lord, has been charge sheeted under section 419, 420, 411, 406, 409, 467, 468, 471, 379, 120 BIPC, my lord. Charge sheet shows, my lord, there are altogether 15 witnesses, my lord. In the meantime, my lord, 12 witnesses have already been examined.
Total witness 15.
15
12टा साक्षी हेलेनी
12टा साक्षी हेलेनी
अपन कस्टडी से period से 25/11/2020
and some of the co-accused persons have already been investigated by this. Okay. I have supplied that copy of the deposition along with that bail order in respect of co-accused.
What the witnesses have stated against you?
Witnesses have stated in omnibus manner and some of have also not supported the case manner.
It's a master tribal offense.
All are tribal London magistrates.
And who have been released on bail?
I have supplied that one is Lalit Soni, another is Saroj Kumar Pushti. Lalit Soni admitted to bail by the Honorable Apex Court, my lord, and Saroj Kumar Pushti was released on bail by this one, by my lord.
Yes, Mr.
Yes. Some of the witness supported the case.
No, magistrate tribal offense.
Yes.
the item number. This is 11 the first item. BLAPL number 3835 of 23. The learned counsel for the petitioner submitted that the petitioner was taken into judicial custody in connection with this case on 25/11/2020, and the offences under which he has been charged sheeted are triable by magistrate. And in the trial court, out of 15 charge sheet witnesses, 12 witnesses have been examined. So he has filed the deposition copies of those 12 witnesses with a memo which are taken on record. Further submits that no clinching evidence has come on record against the petitioner. He further submits that 2 of the co-accused persons have been granted bail, and they are Soroj Kumar Prushti, who has been released on bail by this court in BLAPL number 6919 of 2022, and Lalit Kumar Soni by the Honorable Supreme Court in Criminal Appeal number 2366 of 2023. He files the copies of the bail orders with a memo which is taken on record. Land counsel for the state as well as land counsel for the bank oppose the prayer for bail. Considering the submission made by the land counsel for the respective parties, the nature of accusation against the petitioner, the period of detention in judicial custody, the progress of the trial so far, release of the co-accused persons on bail, I am inclined to release the petitioner on bail allowed. Yes, what about the connected case? Same though, it account.
9211 of Nellimal information.
No, this is a connected matter
1515. Devati
Yes.
Sajra.
Yes.
He is the friend of the Lala Amrut Sagar Rai, and he was pleased the gold of IIFL.
No, here in against him, these are all magistrate tribal often.
Yes,
all are must. So since when he is in custody? 30/11/2020. All right. Hard the Land Council for the petitioner, Land Council for the state, considering the submission made by the Land Council for the petitioner that the petitioner is in judicial custody since 30/11/2020. And some of the co-accused persons, namely जोड़ा कही दी जन जाको bail दे देवे. Out of the 15 charge sheet witnesses, 12 have been examined. Offences are triable by magistrate. Bail allowed. Hello? Yes.
Item 12.
Okay. Yes, may I please, Lordship?
Item 12. Yes, Mr. Da.
Yes, ma'am. The present petition has also been charged under section 409, 419, 420, 467, 468, 470, and 120 and 34 IPC. Similar allegations there are altogether 15 charge sheeted witnesses, my lord. Out of 15 charge sheet witnesses, 9 witnesses have been examined, my lord. And it is alleged in the first information report, my lord.
Wait. 15 ru 9 ହେଇଛନ୍ତି.
Yes, ma'am.
And custody ହେଉଛି 25/11 25/11/2020. And offences are
all are tribal magistrate
409,
419,
419,
420, 467.
Anybody has been released on
No,
bail?
my non has it released.
Okay. So what is the allegation against you?
It is alleged that that one Lipuna Behera, my lord, lost the affair, my lord. It is alleged that he handed over some documents, not the present petition specifically, stated in the first information report, and he handed over some documents to one Harmun Das, my lord. And subsequently it alleged that Harmun Das, in connivance with the present petitioner, misused that documents and used that documents for availing loan, my lord. This is the case of the prosecutions.
What evidence has come against you?
no specific evidence has been
That I have
emerged.
already filed.
I have supplied that evidence copy, my lord. And no specific evidence has been emerged against present petitioner, my lord. That is in omnibus manner. That past information clearly speaks. He handed over all the documents to one Harmon Das.
ଯୋଉଟା ଇଏଟା ହେଇଛି ସେଇଟା କେବେକାର? ନାଇଁ ସେଇ ଯୋଉ ଲୋକଟା କହିଥିଲା ଇନଫର୍ମାଣ୍ଟ କେତେ ନମ୍ବର ସାକ୍ଷୀ?
PW1 mail, Lipuna Behra mail, examined as PW1 mail. He specifically stated the first information. He handed over all the documents to one Harmon Das mail. Subsequently, he somehow rather developed his statement and stated that he handed over all the documents to the Harmon Das and present petitioner along with others mailers. But that story is not appearing in the first information report, my lord.
No, he said that you and Dilima, they received the Aadhaar card from him.
But that,
and Suman Mandal
yes, ma'am.
and obtain their signature in different documents.
That's true, yes, ma'am. That story is not appearing in first information report, my lord.
Where is the FIR?
That FIR has been annexed with the petition, my lord, annexed to one, my lord. That is also with the learned state council. That is not legible copy, my lord, but that is available, ma'am. With my lord's permission, 2018 ମସିହାରେ ହରମନ ଦାସ ଯିଏକି ସିକ୍ୟୁରିଟି ସଂସ୍ଥାରେ କାର୍ଯ୍ୟ କରନ୍ତି ତାଙ୍କ ସହ ପରିଚିତ ଥିଲା। ସେ ଆମ ଅଫିସକୁ ନିୟମିତ ଆସନ୍ତି। ଆମ ପାରେଶ୍ୱର ସାହିର ସୁମନ ମଣ୍ଡଳ ବୋଲି ଜଣେ ପିଲା ଚାକିରି ଖୋଜିଥିଲା। ସେ ମୋତେ ବହୁତ ଅନୁରୋଧ କରିବାରୁ ମୁଁ ଥରେ ହରମନ ଦାସଙ୍କୁ ଗୋଟାଏ ସିକ୍ୟୁରିଟି ଗାର୍ଡରେ ଚାକିରି ବିଷୟରେ କହିଲି। ହରମନ ଦାସ ସୁମନକୁ କହିଲା ଅଫିସରେ ସିକ୍ୟୁରିଟି ଗାର୍ଡ ଭାବରେ କରାଇ ଦବ ବୋଲି କହିଲା। ଆମେ ଦୁଇ ଜଣଙ୍କୁ ଆସିବାକୁ କହିଲା, ଆଣିବାକୁ ପରାମର୍ଶ ଦେଲା। ଏହାପରେ ଡିସେମ୍ବର ମାସ 2018 ଚାକିରି କରିବା ପାଇଁ ମୁଁ ସୁମନ ମଣ୍ଡଳ ସମସ୍ତ କାଗଜପତ୍ର ସହ ହରମନ ଦାସ ନୟାସଡ଼କ IFS ବ୍ରାଞ୍ଚରେ ଦେଇଥିଲି। ସେ ସୁମନ ଠାରୁ ଆଧାର କାର୍ଡ ଓ ସାଧା କାଗଜରେ ଦସ୍ତଖତ ନେଇଥିଲା। ଯେହେତୁ
ମୋର ତାଙ୍କ ଉପରେ ବିଶ୍ୱାସ ଥିଲା, ମୁଁ ଭାବିଲି ଏହାକୁ ସୁମନର ଚାକିରି ପାଇଁ ଓ କାଗଜ ଦସ୍ତଖତ ନେଇଛି। ତାପରେ ସୁମନ ଅନ୍ୟ ଆଡେ ଚାକିରି ଏବଂ ସେଥିପାଇଁ ଗଲା ନାହିଁ ଏବଂ IFL ରେ ଯେତେବେଳେ ହେବ ସମୟ ଦିଶୁନି, ଜଣା ପଡିଲା ଯେ ମୋର ଓ ସୁମନର କାଗଜ ଗୁଡ଼ିକ ବେଆଇନ ଭାବରେ ବ୍ୟବହାର କରି ଏବଂ ଆମର ବୟସକୁ ଦସ୍ତଖତକୁ ବ୍ୟବହାର କରି ସେ କାଗଜ ଆମର ଜାଲ ଫଟୋ ଲଗାଇ ଏବଂ ଅନ୍ୟ କାଗଜକୁ ଜାଲିଆତି କରି ହରମନ ଦାସ, ଲାଲା ଅମୃତ ସାଗର ରାୟ ଆଉ ଜଣେ ସହକାରୀ ନୀଳିମା ଲେଙ୍କା ସମସ୍ତେ ମିଶି
So whatever documents he has given, that is given to
Harman Das.
Harmon Das.
Yes.
But you see in the evidence, he is right in his submission that in the evidence he has developed a new story that he has given these documents to Lala Amrit Sagar Rai and Lilima Lenka,
along with
received
Harman Das.
Aadhaar cards from myself and Suman Mandal. In paragraph number 1 towards last it has been stated. Though in the FIR story is that those documents including Aadhaar cards, those are given to that Harmon Das. Are the learned counsel for the petitioner, learned counsel for the state. Learned counsel for the petitioner submitted that the petitioner is taken into judicial custody in connection with this case on 25/11/2020. And the offenses are triable by magistrate, and in the trial court, out of 15 charge sheet witnesses, 9 witnesses have already been examined. And though the informant Lipun Behera in the first information report has stated that he handed over all the documents to one Harmon Das for arranging a job for one Suman Mandal. But in his evidence, he has stated that some of the documents were also given to the petitioner and Lilima Lenka of IIFL, and they obtained their signatures on different documents. Land Council files the deposition copies of the witnesses examined so far, which are taken on record, and submits that in view of the nature of accusation against the petitioner and the development of story during trial, and since the offences are travelled by magistrate, the bail application may be favorably considered. The deposition copies are taken on record. Land Counsel for the state opposed the prayer for bail, considering the submission, nature of accusation against the petitioner, nature of evidence adduced so far in the trial court, fact that the offences are travelled by magistrate. Taking into account the period of detention, I am inclined to release the petitioner on bail allowed. Yes, Nilima Lenka.
Same.
Application number is 9211.
Right. What is the date of custody?
Lordship same 25/11.
25/11 করে সেটা এই যে সেকেন্ডটা নীলিমা লেঙ্কার তার দিয়ে যে কনেক্টেড ম্যাটারটা আসেনি 9 to দেখুন আইটেম নম্বর 12 ର ହଁ সেটা ତା ଦେହରେ କନେକ୍ଟେଡ୍ ମ୍ୟାଟରରେ ତାର ଡେଟ୍ ଅଫ୍ କଷ୍ଟଡିଟା ଲେଖନ୍ତୁ ହ୍ୱାଟ୍ ଇଜ ଦି ଡେଟ୍ ଅଫ୍ କଷ୍ଟଡି
25/11.
ହଁ
25/11.
ହଁ 25/11/2020 ବାକି ସବୁ ସମାନ ରହିବ କାରଣ ୟା ନା ବି ସେଇ ଏଭିଡେନ୍ସ ରେ ଆସିଛି ତା ଦେହରେ ନାହିଁ ଏଫଆଇଆର ହେଲା ଅଲରାଇଟ୍ ବାକି ଆଲାଉ କରିଦେବେ yes
I may be pardoned to mention item 10 again.
yes next
Item 13.
item 13
Not in that all the my appearance will be recorded now.
yes, Mr. Hard, Mr. Ashit Kumar Chaudhary, Land Counsel for the bank. Yeah.
I am for some informant also affected party because
bank mu lekhichi kon lekhiyo
294 data PS I am for the informed. In all other cases I am for the
na ei jo item number wise koi diyantu mu lekhi debi mu lekhi deli you are appearing for the bank so that covers everything yes
all the cases
yes obviously sabu case yes item number 13
my lord this case is also the connecting case of item 11 my lord. The offense under section 419, 420, 411, 406, 409, 467, all magisterial tribal my lord.
No, this 512023, this is connected to item number 11.
My lord.
Mr. Tripathi.
Yes, my lord.
Is your case connected?
5120.
5120.
Here, out of
12 out of
15 charge sheeted witness
12
in the month of August 12 has been examined. Therefore, he jaito sorry jaito bode. Yes.
No. See, ei para se ta thare connected achi.
Connecting
item number 11 sangere tenu item 11 ର ଯାହା order ସେଇଆ ହବ ଆପଣ ନମ୍ବର ଦେଖି ଦିଅନ୍ତୁ ଆगे PS କେସ୍ ନମ୍ବର ଦେଖନ୍ତୁ PS କେସ୍ ସମାନ କି
297
item 11 3835 of 23
PS केस कितने देखो ना
This case 297.
और ये थे
Mangalabag case
11
297. 11 connected matter 11. Paraton na.
नंबर कैसे कौन होगी 5.20
पैसा sure.
It's reversal item 11 now.
1151.
Mr. Tripathi, this that is 297. So से you एगार नंबर जे ऑर्डर हिची ताकि करी खाली डेट ऑफ कस्टडी टा लिखिबे केबे
Malo dash since 9/2/2021.
9/2/2021 हला allowed connected to item number 11. Yes, next one.
Malo sub item number 2 also that is connected case in same case pilot.
Sub item number 2 means BLAPL number 14445.
14446 malo.
अच्छा
6 ना 5
6 PS case 297.
6 টা দেখলে আউট ওয়ার্ড এর সেকেন্ড ভার্সন হ্যাঁ আর পিএস কেসটা দেখিবা हाँ 297 ठीक আছে তো সেম অর্ডর পাস করিবে আইটম 11 রে যা পাস কলে 5120 রে যেটা লিখিলে সেটা লিখিবে এথরে 14446 हाँ কস্টডি ডেটটা কোন
Custody date malo 9/2/2021 malo.
Connected to item number 11. Date kete custody date
9/2/2021.
9/2/21. Okay. Now another matter.
Another matter, my lord. This is the connected case of item number 10, my lord. And in this case, PROCEEDINGS-COURT Saroj Prushti, Lalit Soni, Satyam Pradhan, they have been already been released on bail. This petitioner is on similar footing to Prakash Chandra Sahu.
এটা ডকাইতি কেসটা
My lord, okay.
তো ইয়ে সেই যে whether he is a staff of the bank or that involved in the dokaiti.
As per the statement of the co-accused, it is he is involved in dokaiti.
Though it rejected.
My lord, one Prakash Sahu is on similar footing, my lord.
No. I have rejected Santosh Bui's application also on that ground.
395.
395 it's rejected. Next. Item number 14445 of 2020.
item number 10 your lordship.
Item number 10 reject कर जैसे जो देवाशीष हाजरा rejected. Yes, next case.
I apologize.
Yes, item number 14.
Item 14.
For alleged offence, my lord, 307, 353 by 24 of the IPC read with 2527 outside. The main accused, Souri Nahaka, has already been released on bail. The petitioner is in custody since, my lord, 11/9/2017. Your lordship turn to page 83.
माइक पर को
ये पढ़े चल रही
Yes.
बस custody page 83, my lord.
Yes.
Para 3.
Yes.
I also warned him to not to open fire as we are on duty, Khalikot PS, but in the vain, and the said person continued open fire. His aiming me and my staff, as a result of which one of the bullet hit through the minor mirror of our PS vehicle and another bullet hit to one of my staff, namely Prashant Roito. Finding no
This person Miller having a series of criminal antecedents.
She's
Hardcore
Sauri
criminal-
Naik also having the antecedent, my lord.
No, that is
He
not
has-
reflected. That is
No,
not
he
reflected.
has also granted bail since 2019, my lord. The petitioner is in custody, my lord, since
How many cases are there?
So I have
Uh,
not particular, but it in the rejection order, it was mentioned that accused is a hardcore criminal and he is threat to society. It has also been
and near about 6 years he is in custody, my lord.
Of cases.
Near about
No,
6
it's
years
all
he is
right.
in
I will take
custody.
this instruction.
All right. The learned counsel for the state submitted that in the rejection order, it is mentioned. कोड लिखा है जी टिके देखेले
Yes, Miller.
हाँ that
Page 79.
that the case record indicates that the petitioner is involved in series of cases
No,
under
he having the
different
18
police
cases,
station,
I am filing the affidavit, my lord.
and there is every possibility of his absconding. Learned counsel for the state seeks some time to obtain instruction on the criminal antecedent put of this matter. Put a saptah forever. Yes.
More than 6 years he is in custody, my lord. Date may be fixed, my lord.
Put a saptah for a date. Put it. Yes.
Affidavit I have already filed, be taken on record, my lord.
Affidavit ID file karo. Learned counsel for the petitioner has filed a comprehensive affidavit relating to the status of the criminal cases which are taken on record.
And also served to the state
Served
council.
a copy on the Mr. Tripathi, a comprehensive affidavit ରଖନ୍ତୁ ଆଉ ଦେଖିବେ ଆ ଛଡା ଆଉ କଣ କେସ୍ ବାସ୍ ଅଛି ଦେଖିବେ. Yes.
Item 15.
May I please, Your Lord? Petitioner is in custody since 28/11/2019 for the alleged commission of offence under section 302 of the Indian Penal Code. Initially, a FIR was registered against one unknown person. Subsequently, basing upon the confession,
କଣ ହେଇଛି?
petitioner is in custody since 28/11/2019.
28/11/2019.
My lord.
And what are the offences under which charge sheet submitted?
For 302, my lord, charge sheet was submitted. Offence under 302.
No other offence.
No.
You approached this court earlier or?
My lord, this is the second round.
Second round.
This honorable court filed order dated 25/11/2020.
Yes, I have taken into account the eyewitness Salami Boot and Bahanani Boot.
My lord, due to want of chemical examination, the trial could not be proceed. For
এপর্যন্ত trial আরম্ভ হয়নি?
18/10/2023 your lordship may kindly say I was even the certified
status report ମଗାଇନି ତ ମୁଁ ସେଇଥିପାଇଁ କହୁଛି. Have you got the copy of your the order sheet of the trial court with you?
No, my lord, on the last occasion I was submitted the last page.
The chemical examination is complete now, Your Lordship.
No, he said that 2019 ରୁ କଷ୍ଟଡି ରହିଲାଣି ଏପର୍ଯ୍ୟନ୍ତ ଟ୍ରାଏଲ ଆରମ୍ଭ ହେଇନି ସେଇଆ ମୁଁ କହୁଥିଲି ଯେ ଅର୍ଡର ସିଟ୍ ଅଛି.
I was submitted last 18/10 ରେ ଦେଇଥିଲି ଅର୍ଡର.
ଏଇଟା ହଉଛି 21/7/2023 ର ଆ ଭିତରେ 6 ମାସ ହେଇଗଲାଣି ନା?
ଆଉ ମୋ କଣ୍ଟାକ୍ଟ ନାହିଁ.
ଲେଖି ଦିଅନ୍ତୁ. But your instruction is that trial has not commenced.
ଆଉ କଣ୍ଟାକ୍ଟ ନାହିଁ.
All right. The learned counsel for the petitioner submitted that the petitioner has been in jail custody since 28/11/2019 and he has produced the order sheet dated 8 certified copy of order sheet dated 21/7/2023 which indicates that on account of non-availability of the CE report, the trial could not commence. है ना? Land counsel for the petitioner submits that he has not obtained the up-to-date instruction about the status of the case. Let a status report be called for from the Land trial court. बाकी usual order कर दे गोटे सप्ताह पर पकई दे. Yes.
Item 16.
My lord, may kindly see the agitated 12, 10, 20.
Status report मगा ହେଇଥିଲା.
That has come in flag A.
चौबीसटा विटनेस रु 4टा विटनेस ହେଇଛନ୍ତି ବୋଲି ଆସିଲା report. You are in custody since when?
July 2020.
And you are a man from state of Bihar.
Yes.
So have you obtained about the address?
Lordship may grant me 2 more weeks time, Your Lordship.
My lord, may kindly see that 12, 10, 23 onwards, they have been not taking instruction.
City order pass ହେଇଥିଲା. So get that instruction,
My lords.
the period the status report submitted by the London trial court dated 3/11/2023, which indicates that out of 26 charge sheet witnesses, 4 witnesses have been examined. है ना? The London Council for the State submitted that as per order dated 12/10/2023, he is yet to receive instruction regarding address verification, and the matter may be taken up 1 week after. Put up this matter in the week commencing from 19th of February 2024.
Item 17.
May I please, Your Lordship.
Yes.
I am in custody, my lord, since 12/12/2019. My earlier application was rejected, and last order by order dated 13/10/2023. Lordship directed the IIC to produce the relevant witnesses for examination.
Yes, what happened thereafter, Mr. Pranangi?
My lords, he is not in a position to send the records. What I pray, my lords, better your lordship may call for a report from the learned court as well as the depositions, my lords.
Okay, what is your instruction?
I have not also received the instruction.
Because there was a specific
yes,
direction,
I have already sent.
free copy was also
yes,
given
that
to
was
you.
also sent, my lord. With the
He
Barampur
said that there are eyewitnesses, namely Tarini
Tarini
Chandra
and the
Bhanti
Niranjan Pradhan.
and Niranjan Pradhan.
My lord.
And
It has
direction was given that to produce those 2
My lord.
witnesses.
It has communicated. I have taken instruction in the meantime.
All right, had the Land Council for the Petition, Land Council for the State. An order was passed on 13/10/2023 directing the IIC Barampur GRPS police station to appear before the Land trial court, receive summons in respect of eyewitnesses Tarini Chandra Mahanti and Niranjan Pradhan, and to ensure their attendance before the Land trial court on the date fixed. Neither the Land Council for the State nor the Land Council for the petitioner in a position to say what happened in the trial court, whether the 2 eyewitnesses were examined or not, in view of in such state of affair. let a status report be called for from the land and trial court, and if the aforesaid two witnesses have already been examined, the land and trial court, while sending the status report, shall send the Xerox copy of deposition of those two witnesses to this court, on receipt of which copies shall be handed over to the land and council for the petitioner, so also to the land council for the state. Put up this matter, go to 1 week after. Yes.
My lord, accused in custody 14/2/2021 and offense under section 498 to 94 302 34 B 34 IPC.
Please, Your Lordships. The alleged offence involved is under Section 20B2C, read with Section 29 of the NDPS Act, Your Lordships. The petitioner is in custody since 5/9/2021. Your Lordship was earlier pleased to reject the bail application, and this is the order, wherein Your Lordship had directed the trial to be completed within a period of 6 months. That was in February 2020.
Custodial 5/9/2021.
2021.
Yes.
Your Lordship,
So when you approached this court for bail last time,
Your Lordship was pleased to reject the bail on February 2023. I've given the
ELAPL number.
I copied it.
So there was a direction to conclude it within 6 months.
Your Lordships.
What is the status now?
Status report has come, Your Lordships, flag R.
Out of 25 charge sheet witnesses, 4 witnesses have been examined. So this man is from UP.
Yes, Your Lordships.
So
I had also given the copy that I had served last October. This is your
copy
Lordship had directed
address verification.
Address verification thing.
Lords, we have already made 2 correspondences to the SP Ghaziabad, Your Lordship. Lords, may grant us 2 more weeks.
Local sureties in fact.
Local surety document verify.
Lords will verify the same also. Lordship may grant us 2 more weeks time.
From November I have given.
October na November
November,
order ta
November I have given the copy.
ଆଉ
October.
ଆପଣ ଯଦି ନ ଆଣିବେ କହିବେ if you express inability to ascertain the correctness of the address of the petitioner mentioned in the first title, so also after receiving the documents of the local sureties, the inspector in charge of Kesinga police station has been asked to verify the same and report about the authenticity and genuineness of the bailer, authenticity of documents and genuineness of bailers. But the instruction is still awaited and the matter may be taken up 1 week after. Put up this matter in the week commencing from 19th February 2024. এইটা একটু রকি দিয়ন্তু এটা যে আগর রিজেকশন yes
Item 20.
yes Mr. S. Devabrata Reddy, this is a okay. Mr. Naik is there. Okay, Lekhi non appears for the petitioner, Mr. Sarthak Naik, and special public prosecutor for state of CBI is present. Case is adjourned. This saptah pore for the yes next.
So after 3 weeks.
3 weeks. All right. After 3 weeks.
Item 21.
Please, my lord.
Yes.
My lord, here the petitioner is languishing in jail custody since 1/9/2017. My lord also pleased to dispose of earlier bail application, that is BLPL number 8935 of 19, given a direction on 5/3/21 that the trial to be concluded within 6 months. That was the direction. But the trial has not yet been concluded. Only 5 to 7 witnesses has been examined.
You have come how many times to this court? As it appears from
No, the last occasion, my lord also pleased to dispose of the bail application by granting the interim relief.
See order ta kain? What is the last order?
That order.
In which you are granted interim bail.
My lord, he was surrendered. He was surrendered in time.
तार नंबर केते जो फिर आपन बेल दिया इतला?
That number, sir. It is 7458. No, this is the 745.
745.
No, sorry. 7 for the present application. Yes. That is 9239 of 17. No, 8935, sorry.
ठीक से कुहंदु.
Sir, 8935 of 19.
8935.
35, sir.
Of 2019.
19.
तार दिन आपन को बेल दिया इतला.
Yes, interim bail.
हाँ. So वर्तमान position कौन? कितना
Only my lord 6 to 7 witnesses has been examined.
All right. The learned counsel for the petitioner submits that the petitioner was taken into judicial custody on interim bail to the petitioner in BLAPL number 8935 na 9819 of 2020.
Sir. 9819 of 22. Sir, yes. Sorry, sir.
9819 of 2022. And after availing the interim bail period, he surrendered at right time. In view of such submission, status report magay debe, hala? Whether the petitioner surrendered at right time or not, that report, hala? Gote saptah pore pakei den. Yes. That item is number no. Yes.
Item 22.
May I please, your lords? My lord, this is the successive bail application, my lord.
302 case.
My lord. Earlier bail application was rejected, giving liberty to renew the prayer after examination of the eyewitness.
In
the meantime, all the eyewitnesses have already been examined.
What they have stated is
PW 1467.
No. Who has stated against you?
My lord,
Out of the 4 eyewitnesses examined,
Sunita Hakia, PW1.
whether he has stated anything against you? हो कौन बुझी पारनाथि ना कौन जो चारिटा विटनेस ହେଇଛନ୍ତି ତା ଭିତରୁ କିଏ ଆପଣଙ୍କ ନାଁ କହୁଛନ୍ତି?
None of the
ସେୟା କହୁନାହାନ୍ତି. Yes, Mr.
Lords, PW 10 has stated, Your Lordship. 2 of the eyewitnesses have turned
Wait.
hostile.
Let us see. PW 10.
My Lords.
PW 10 deposition copy kahin?
She has stated, my lord, she is not a.
Just a minute. I know the accused standing in the dock. I know the deceased. She is my sister-in-law. She died. Nearly so and so. I, along with 6 to so and so women, with the deceased, were sitting on so and so to give earth to a dead man of village as per our rituals. And at that time, accused Bhagu Saika, okay, this petitioner,
Lordship,
came with a tangi and gave a blow to the back of the neck, waist, and hand of the deceased, caused bleeding injury on her. I have seen when the accused assaulted the deceased by means of tangi. The deceased showed her left hand in protest and the blow hit on her little finger, for which the said finger was cut down. Yes, sir. So,
My lord, he is not a witness. Even 161 has been not recorded. He is a witness to the inquest, my lord. My lord. Even his 161 has not been recorded, my lord.
This is not a fact that I am not stated before you nearly smart.
He is a inquest witness.
I see you na କହିବେ.
No, I am giving the certificate.
Only to witness to the तार ये statement नहीं 161 नहीं. No, inquest reporter से ही था पर witness.
But
in addition to that, whether he is an eyewitness or not, that is to be seen.
He is not a. She is not an eyewitness.
No, से verify करते नहीं परा.
$161 is not there, Your Lordship.
No, why then you should have the very first question. We should have been put to that witness that you have not given any statement before the police that you are an eyewitness to the occurrence.
My lord, that question was asked before the London trial court.
कोडी काई देखिला
That
contradiction आनले खाली आपण एया कहि नांती से कथा कहि नांती आपण ए जो जिंसडा आपण कहउछंदी अजी जे आपण आई विटनेस हिसाब रे कोनसी स्टेटमेंट देई नांती ए जिंस कोड पचारचंदी.
But while he was choose to be as examined the counsel before the London trial court, as opposed that he is a witness to the inquest.
कि कोन हेची आपण सेठी ट्रायल कोर्ट रे मु जाननी आपण जेतले क्रॉस एग्जामिनेशन करिवार गोटे अपॉर्चुनिटी दिया जाउची गोटे इनक्वेस्ट विटनेस आसिकिन आई विटनेस हिसाब रे कहूची आपण ता किछि पचारिबेनी जे आपण तो आई विटनेस नहंती आप पुलिस पाखरे किछि स्टेटमेंट नाही ए सब विषय रे पचारिबे ना नाही. So that statement is not available.
No, Lordship.
Do you want to take instruction whether 161?
Okay, I will take instruction.
The learned counsel for the petitioner submitted that out of $11 witnesses examined so far in the trial court, only PW10 deposed as an eyewitness to the occurrence and implicated the petitioner to have assaulted the deceased with a tangi. However, the police paper would indicate that PW10 is a witness to the inquest and no 161 CRPC statement is available on record. The learned counsel for the state submits that he has received the case diary but he may be given, and no 161 CRPC statement is available with him of PW10, and he may be given some time to obtain instruction as to whether any statement of PW10, any 161 CRPC statement of PW10 is available on record or not. Put up this matter next week. Next week, Niyaji Pujar Dion.
Lordship.
Etaku deposition copy taku taken on record kar do. Rest of the matter next week.
Item 40, the interim bail, the father has died, and the last item. Yesterday, my associate has mentioned, and it is.
Anichandi kone.
Discussion not written received, but one should be instruction that died.
I will WhatsApp रे उटे message कर देलेनी. लेखिबी ना रखिबी जते आपण कहबे ई करियो मजे देबे कागज खंडे लेखिन मु डाक दिबो
से मो कथा हिंदी गला actually IAC and others are law and institution outside the police jail
केबे एक्सपर्ट केबे कले
एक्सपर्ट 24/11 डाक्तरखाना मरिचंती ता रिपोर्ट देछि ये आदिवासी लोक 15 16 17 तांकर
सोमवार दिन नहीं आसो मैटर तो है
Pardon to mention item 36, my lord. My lord,
Last time, because the record was not available to the council, that is why you not directed yesterday, but not directed to all the matters today.
It will come next week, Mr. Dawud.
My lord, item 38.
Uh-huh.
One matter has been, your lordship, on the last occasion directed to list the connected matters. One matter has left out, my lord. I am giving the number.
The file press out होनी आपण जदि press out होनी तारो गोटे जेरोक्स कॉपी कर दे दियंतु रेकॉर्ड क्रिएट करै देबो बुझिले वो मैटर अछि ताको जेरोक्स कॉपी करी रजिस्टर दे देले if the record is not pressed out they will create a record.
my lord, pardon to mention item 36. I'm seeking permission to withdraw item number 36, my lord.
Withdraw. All right.
All right, my lord.